and you're smoking. This is not a bar. This is not a nightclub. I'm beyond insulted. This is a legal matter. We're not meeting for coffee and cigarettes. So fix that. And when your case is ready to be called, in the court. Okay. I'm sorry. I had a matter in the courtroom that I had to attend to. Mr. Todd.
I'm trying to turn the volume up, ma'am. So far, I'm happy. Give me 1 second. I'm going to turn the fan off. It's making some noise here.
He's first on the informals. When I call this case, can you rename him?
There's my volume button. Okay.
Mr. Todd, this is a legal proceeding. You are in a virtual courtroom and you're smoking. This is not a bar. This is not a nightclub. I'm beyond insulted. This is a legal matter. We're not meeting for coffee and cigarettes. So fix that. And when your case is ready to be called, I will call you. Your officer is not here yet. Your case is not set until 9 o'clock. So therefore, I can't call your case for a few more minutes, but you need to address your environment and act like you're in a court of law, please. Mr. Gagniak, I'm ready for your case. While I'm on this case, could you kindly check in, people? Yes, and I can. Yes, I can. Thank you, ma'am. All right, Patrick, are we ready on Miss Pickett's case?
We are. And I had messaged you both phone number and an email, as well as some personal information, if you want to add that to the file, please.
What's today, Madam Clerk? Excuse me. That's my little calendar.
6. Oh, I don't know what I have over here. Thank you. It's D-Day.
What's today? Oh, you're right. Okay. Let's mute Mr. Todd. Apple is here. What's that? Oh, that she's 2. Okay. That will be number 3. Calling the case number of 2500605. This is the City of Royal Oak versus Brandon Pickett. Your appearances, please.
Good morning. For the record, Patrick Agnick, I appear on behalf of the defendant. If you want to state your name that you be preferred to be addressed as for the court.
Yes, Cavani would be fine.
But you do acknowledge your legal name, otherwise, is Brandon Pickett.
Yes.
Okay. All right. So the legal name is Brandon Pickett, and your preferred name?
Cavani, C-A-V-A-N-I.
Oh, okay. C-A-V-A-N-I.
N-I. Yeah.
And is your last name when you go by your preferred name, do you use the last name of Pickett?
No, Young.
Okay.
Y-O-U-N-G.
Okay. And do you have preferred pronouns?
Yes, she, her.
Okay, thank you.
No problem.
Give me 1 second. I know I'm looking down. I'm not ignoring you. I'm noting your preferences in the file, please.
Okay, no problem.
Okay, so Ms. Cavani, you've stated your legal name and your preferred name on the record, And
Yes.
today's the date and time set for the arraignment. Counsel, how are we going to proceed on that?
Good morning. Again, I did speak in private with my client. Did go over the one misdemeanor charge. You understand what you're charged with, is that correct?
Yes.
So given the acknowledgement, I would ask the court to waive any further reading, requesting a not guilty plea to be entered, and there will be a request for appointed counsel. As I stated earlier, phone number and email were chatted to the court, and the Wolcott address in Ferndale, if that made the court file, that's a valid mailing address.
Okay, so we waive the formal reading. I didn't hear if you said defendant stands mute or pleads not guilty.
No, not guilty is fine.
Okay, defendant pleads not guilty. A not guilty plea shall enter. The request for assigned counsel is granted. Counsel shall be assigned for Ms. Young. Okay, let me check the chat, please. Okay, we have updated Zoom here. How the chat comes in, okay. Defendant, I did have the Walcott, but I'll put the phone number ending in 3928.
Correct.
Okay. All right, so let's see. I confirmed Walcott. Okay, what do you have to say about bond and bond conditions?
Did appear here timely this morning, reviewing the charges here. My conversations with my client, and again, without the benefit of the police report, it doesn't appear that there's any additional charges that would be otherwise forthcoming. So with that said, generally a charge of this nature would be resolved in most times a civil infraction plea. So if you would consider a personal bond, I don't believe that any conditions are appropriate unless there's information that I don't have. But if you would consider a straight personal bond, and make that request, please.
Okay, 1 second, I'm looking. Something out of Berkeley in 2023. All right, the court is setting a $3,000 personal bond with conditions. You are to personally appear, whether it is today, like you did today by Zoom, or in person as ordered by the court for any and all court appearances, Ms. Young. That means any pretrial conferences, status conference, trials, sentencing. You have to abide by any judgment entered in this case, and you have to surrender to serve any sentence imposed. You shall not leave the state of Michigan without permission of the court. You are not to commit any crime while released. You shall immediately notify the court in writing of any change of address from Wolcott or the phone number ending in 3928. You shall not use alcohol, marijuana, or any other illegal controlled substance. We will set this matter for pretrial. The notice to appear will be sent to the Ferndale address, and you will have assigned counsel for going forward. Is there anything further requested or required of the court on Ms. Young's case?
Just one point of clarification. I heard no alcohol or drugs. Is there a testing regimen that's being ordered?
There is not,
Understood.
but that doesn't mean we could go out and violate the bond.
Understood. I will, I'll reach out to you next week with all my information and we'll talk the next steps. They're going to reset the court date in about a month or so.
Okay,
Okay, and you have Judge Meineke, so when you get your notice, it'll have.
Right stomach.
You say? Oh, you want it back this way? Let me try to keep you on things. So don't move it.
Yeah, sorry. Backwards from what I.
I mean, people are gonna think we're trying to promote a Weight Watchers commercial. Forget about Mr. Keller,
Yeah.
one of the greatest athletes actually in Southeast Texas. That man back there. That's a fact. Oh, he rolls his eyes, but he was. It was highly recruited guy and great athlete. And the kids are.
My son was not married.
Yeah. Leland Bulldogs, right? Yeah, I'm sorry. You made all district, didn't you? He's being shy. He's humble. All right, so let's get to work. I've got Taviante Fontenot. Maybe I don't. Taviante Fontenot, this would be Mr. Burbank's client. Well, is Taviante Taviante Fontenot in the courtroom? No, I asked. In the jail?
Yes.
Okay, well, let's hold off on that. Are these all in the jail?
Most,
No.
mixed.
Darren Patterson, are you around, Mr. Patterson? And Mr. Burbank's your attorney as well. Okay, we got to wait for him to show up. Daniel Raleigh, Mr. Raleigh, again, same thing. Alexis Dixon.
She's a bench warrant, we need to revoke her violation and get her sent back to TDC.
She's here now.
She's here.
Oh, okay. You sound like you have a plan.
Yes, sir.
Okay. Alexis Dixon, she's in custody, huh?
Yes, there's more from me. She's at the Plain State Jail. Ellie, you don't remember where she is?
But she's here.
Yes, I talked to her at the jail center. What do you think?
Wednesday,
Plain State.
but it's in my release date, it's a separate, the officer that got me in. But my, I was released on the second, from Wednesday.
Okay, so you're released. Plain State.
Okay, we call cause number 19-33599, the state of Texas versus Alexis Dixon. That's you. And you here, your attorney and the state's attorney. What we have most recently is a third amended motion to revoke a probation. That's seldom seen here, a third amended, but nonetheless, it can happen. Are the parties ready to proceed here? Does the defendant waive a formal reading of this, and can we proceed by summons?
We're ready, Your Honor, and we can proceed by summons.
Please raise your right hand, ma'am. Do you solemnly swear or affirm any statements that you might make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, lower your hand. There's no agreement on this?
No, Your Honor, it's related to discretion.
All right. This third amended motion to revoke probation in summary, ma'am, states that on June 2nd, 2021, you were sentenced to 10 years in prison, probated for 10 years for the state jail felony of theft. Now that is a higher than state jail felony punishment that you were placed on. You must have had prior convictions. I've got it. I don't even have to look. I'll bet you pleaded true to prior convictions. Yes, I'm looking at the indictment. You pleaded true to paragraphs 2, 3, and 4, which were 2017 convictions out of Shelby County, Texas, for theft, burglary of a building and controlled substance. What happened was that state jail felony, the punishment then of the state jail felony became enhanced as though it were a third-degree felony. So you were looking at up to 10 years imprisonment. Thus, you were sentenced to 10 years in prison, probated for 10 years. Have we had hearings on this before?
I mean, Your Honor, really, too.
We're just going to go to the third amendment.
Well, I can explain kind of what happened.
Okay, help me out.
Are we on YouTube?
Yeah, we are, as much as we can be. Hold on.
Could you
I'm a recovery advocate there, so I talked to the other women
Okay.
with me, so.
All right. Okay. Well, anything else anybody wants to add?
I was a senior recovery advocate there, so I talked to the other women on the microphone, and they really listened to me
Okay.
the way I talked to them. So
All right. So are you confident you're in a better place now?
yes, and
You're going to make more
I have a,
mature decisions that are in conformity with the laws.
yes, sir. I had a job lined up, an actual job with, Social Security taken out and things like that.
Yes, ma'am.
I have a new home to go home to. I have good family support because they believe in me. So
All right. Okay. Well, anything else anybody wants to add? Nothing to stay here. I'm going to find that the defendant has pleaded guilty voluntarily, knowingly, intelligently to allegation number 17, I believe, which is in the third amended motion to revoke probation, committing the offense of theft of property in Liberty County, Texas, of an amount over $30,000, but less than $150,000, occurring on or about March 21st, 2024. She has entered her plea of true voluntarily, knowingly, intelligently. That is enough to grant this third amended motion to revoke probation by a preponderance of the evidence or greater. Your probation is hereby revoked. And this court has listened to the recommendations of the attorneys and as to punishment. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 4 years for the state jail felony, punished though as though it was a third-degree felony because of your prior felony convictions that you pleaded true to at the time of sentencing. And the sentence shall run concurrently with other sentences. So do you understand what has well, the only other thing is, dot all the i's.
And there was no
There any
restitution.
restitution? Okay, that's why I take care of it. Anything else? Do you understand what has happened today?
yes, sir.
Fix this mess that you put yourself into. You obviously know better and you have the tools to do better. So there's no excuse for failure. Failure is not an option with you. Be successful in your life. Can you?
I'm gonna give it my best shot.
No, you want to
Yes,
do
I
it.
can.
Everybody says, I'm going to try,
Well, I'm gonna
but
do
you've got to get over the bar. But the bar set low enough. Everybody can. You can too. Do it.
What's your recommendation?
No, I don't like it. It was horrible.
All right. Anything else? That's all. Thank you. Good luck, man. Uh-oh, we need a thumbprint.
It's just an old thing. I want to make sure.
My hands are all
Stephen Hicks. Hey, Rife. Rife Kimber. You're still on board. Halen Hicks. And then we got a bunch of years.
The Hicks people got past that for the hearing. They'll have to get home to September. That's a murder trial. Contesting is the state.
On Kalen Hicks, who's on that?
That's Mr. Laird, but I'm handling it for him.
He's asking to reset this. Is that the plan? Is that what the state wants as well?
Yes.
Thank you.
Do we already have yours?
Trial date set for July. Well, let's get these pre-trial matters. So we're done. Okay. Michael Peterson.
But I have to get Dr. Holmes.
Yeah, Michael Peterson.
We'll probably should have to set that. Stakes off.
It is. So we've got a motion to revoke probation here in 23-153 and a new indictment in 24-530.
And she was restored to all this.
Yes.
If we fall through here, we'll go up and get full of everything.
Come forward, please. How do you pronounce your first name?
Michael Raven.
Okay, but it's two names though, right? So Michael and Raven, but it's Ravine, not Ravine. It's Raven.
Yes.
Okay.
Yes, sir.
Peterson.
Yes, sir.
All right. You were here with your attorney, Mr. Kimler, and the state's attorney. and your probation officer. Here in 23 CR 153, we've got two things here. In 153, there is a first amended motion to revoke probation that was filed on April 22nd of a year ago. And then we've got a new indictment in 24 CR 530 of a third-degree felony of harassment of a public servant that was filed, handed up by the grand jury on March 6th of 2024. And my guess is that first amended includes that new indictment. Maybe. Yeah, allegation number 3 is out of these 8 allegations of wrongdoing here. Okay, so what today? Have a hearing?
Well, I'm sure the state's, she's gonna plead untrue to the offense, and I'm sure Mr. Boyd would want an opportunity to prove that out.
That's correct, Your Honor.
Are you ready? Do you have your people today?
No, sir. I saw that it was set just to announce that she was found competent. I guess that's what I was looking at.
We'd ask the court to revisit the issue of bond on the. I know her mother's desperate to have loans. Probably that's a professional.
All right, I have a letter from Dr. Edgar Pond dated May 22nd, 2025, where the defendant was evaluated for competency, and the evaluation resulted in his determination that the defendant is competent to proceed to a resolution of her legal issues. I'm going to call this court's Exhibit 1, today's date. 6/6/25. And it is made a part of the record for all purposes, and we'll keep this in a sealed form. Any objection to its,
Without objection. No.
all right, is it made a part of the record for this case? The defendant, this motion to revoke probation began its journey on March 8th of 2024, when the defendant was alleged to have 5 violations of aggravated assault, resisting search, harassment of a public servant, all on February 13th, 2024 in Jefferson County, Texas, and failing to comply with program guidelines and rules of the Moral Recognition Therapy Program, which is good. It helps people make better decisions. And then failed to pay court assessed fees and was in arrears in her required payments for probation and other fees. Then a first amended motion to revoke probation came along April 22nd of 2024 and added allegations 6, 7, and 8. It is alleged that on March 19th, 2024, which would have been about a month, a little over a month after the first 5 allegations allegedly occurred, that she committed the offense of resisting arrest or search. March 19th of 2024 in Jefferson County, Texas, committing the offense of public intoxication on that date in Jefferson County, Texas, committing the offense of injury to a disabled person also on that date. And the defendant is on deferred or unadjudicated probation for the 3rd degree felony of injury to a child or disabled person or elderly person, and it would be what? No, what about which of those? Elderly person.
Yeah, yes, yes or no.
Okay. So when can we have this hearing? As soon as possible.
We can have it within a week, Your Honor.
Okay.
It shall be done. All right. 17th or 18th, y'all pick.
What night?
Today's 6th.
This 17th.
That's gonna be a week after next.
So Friday or
It's a Wednesday. It looks like a Wednesday or
Tuesday and Wednesday.
Wednesday or Wednesday. All right, it's set for Wednesday, 17th? 18th? Okay, here is the order on the finding on reprise. The Dr. Rapon, that needs to be placed in the
Yeah.
seal envelope. And also 24C are the new 530, the new indictment on harassment of a public servant that will with the motion to revoke probation. Shelby Sullivan.
So,
It says there's
Yeah.
gonna be a plea.
well, that's not a plea. I'm trying to get the boss to ask for her to go to rehab. So, yeah, I think at this point, the plea would be premature. I'd like her to try to get some rehab under the belt before this goes on.
You know, they have, we do that.
It's not,
That's a term of
it's not a probation. So, the state hasn't offered probation.
The state has offered probation. Senator Tim with a mandatory jail of 10 days and a $500 fine.
I'm discussing.
Yeah.
They've offered you probation.
Yeah, y'all talk about it outside the presence of 250,000 people. Arlie Weaver. Hey, Ryan. You've got Arlie Weaver, 3 cases.
That's Miss Staub, isn't it?
Huh?
That's Miss Staub, isn't it?
Well, Arlie is missed up.
No, that's her case. I'm sorry. Her case is.
It says 3 cases. It says 3 cases definitive plea.
Yeah, well, I mean, it's an NTRP.
Is that what you're gonna do? I don't see it. There's nothing on the pad.
We just
Oh,
could,
please.
we could plead, we could plead administrative.
Is that what you're gonna do?
Have an updated PSS. It is, when she gets out, I'll kind of explain the situation. She's. This is Miss Weaver again.
Let's see. We got 1, 2. She's on 3 probations.
Yes.
Correct, Your
Okay. I don't see a new indictment. These are just 3 probations where motions to revoke probation have been filed.
Correct, Your Honor.
First amended motions to revoke probation, by the way, all filed in each of these 3 cases on March 24th, 2025. Cause numbers 23CR 2129, 24CR 37, and 24CR 2001 are each called the State of Texas versus Arlie Champagne Weaver. That's you.
Yes, sir.
Present with your attorney, Mr. Kimmler, and the state's attorney. Does the defendant waive formal readings of these motions to revoke probation? Can we proceed in summary?
She does, we made her.
Raise your right hand. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
Lower your hand. Well, there's some similarity here on 23CR 2129 and 24CR 37. In summary, each of these first amended motions to revoke unadjudicated probation in these 2 cases similarly state that on February 5th, 2024, in this criminal district court, you were placed on 5 years deferred or unadjudicated probation for the state jail felonies of theft in 2129 and unauthorized use of a motor vehicle in 24CR 37. Are those allegations true and correct as they are alleged now?
Yes, sir.
There you got 8 violations. What are we proceeding on? Did y'all talk about?
We
that?
haven't touched it. I would just go through the she can have please and true or not true.
Yeah,
That's
to what?
well, just if you would just read someone out the room, she can read out. the
Okay.
list.
She hasn't entered any pleas prior to this, correct?
I believe that she had on 1, 2, and 3, because we held it in abeyance in October of 28th of 2024 to place her on the new probation in 24-2001.
Actually, there are no findings on any of these motions
That's fine.
for probation. Okay. All right, so let's take them up. New. One. States you failed to report to the Jefferson County Probation Office for the months of April, May, June, and July of 2024. And that is similarly alleged in each of these two cases, 23 CR 2129 and 24 CR 37. And that was in violation of your probation order. Is that allegation true and correct in each of these cases? Are you pleading true and correct to that voluntarily and because those allegations are true as they are alleged? You understand that a violation proven by a preponderance of the evidence or greater of one or more violations of probation, that is enough to grant the motions to revoke probation. Probation can be revoked and you can be sentenced up to the full range of punishment in each of these cases, which sure on site that. Which are state jail felonies, not enhanced. So you're looking at in each of these two cases, if your probation is revoked and you're sentenced, you're looking at no less than 180 days up to 2 years in the state jail. In each case, knowing that, do you insist on pleading true today?
Yes.
I find you're pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yep.
Stand by. Happen to these new substantive offenses, and looks like it's numbers 4 and 5.
Which
Assault, family violence, December 21st, 2024. Illegal possession of a controlled substance, February 17th of this year.
is that the Orange County? Is that just-
I didn't say.
It says in Jefferson County. That is not her Orange County offense. It's a Jefferson County
Yeah,
offense.
it is Jefferson County.
The assault was refused from her office. The possession is still waiting for drug results.
Okay. And let's go number 2. This alleges in each case, this violation that you failed to provide verification of performing community service hours as required in each of these two cases. Is that allegation true? Pleading true to that voluntarily and because it is true in each case. Understanding that that also has the same consequences as what we talked about in your plea of true to allegations number 1 in each case. Let's hold all of that and go to this third one, 24 CR 2001. And again, she waives a formal reading of this motion. We can proceed in summary.
She does, Your Honor.
This one was more recently filed on March 24th of 2025. And again, this states that on October 28th of 2024, you were placed on 5 years deferred or unadjudicated probation for theft of service, a state jail felony. Is that true?
True.
And allegations 3 and 4 allege that you failed to report to the Jefferson County Probation Office for the months of November and December of 2024 and January of 2025 in violation of condition 4 of your deferred adjudication order in this case. And allegation 4, you failed to provide verification of performing community service hours as required in that case. Or allegations 3 and 4 in this case number 24 CR 2001. True and correct as they are alleged, and are you pleading true and correct to those voluntarily and because they are true?
Sure.
Find you're pleading true voluntarily and you admit that they are true as alleged. All right. Are there agreements on this?
No, Your Honor, it is
Go
back to the
ahead.
court. She was bench warranted over here from Orange County. Judge Parkhurst and the 260th court has sentenced her to probation and ISF on new, was it
Regular habitation.
Okay, was it older?
From that all these crimes are committed.
There was I guess, an older burglary and a habitation case. And so she had these motions to revoke pending, so she was brought over here. She's 5 months pregnant, and it's my understanding, of course, I'm not an expert on these matters, at least on the female end, but that she has a high risk pregnancy. Again, I'm not an expert, but that's what it's been related to me. And in any case, whether it's a high risk or not, ISF won't take her. And so I'm going to have to get with the 260th of Judge Parker to see how he's going to proceed on
How
that.
many children do you have
One.
already?
Yes,
This will be your second?
yes, sir.
How old is your other child,
7.
ma'am?
7.
So I don't think that ISF or SAP is an option if she's continued on probation. Again, my suggestion would be, I guess, to get an updated pre-sentence report so the court can be aware of what her current situation is and how she's
On
obstacles that she's had while on probation before you determine whether
these cases, is there any restitution?
No, Your Honor.
No, on
Not that I believe.
either.
I don't believe so.
I think that I think she would benefit from inpatient rehabilitation. I think you would agree with that, is that right?
Yes,
Have you spoken to Franklin House or have you?
Yeah. Yes, sir. I was there before, the day before I went to court in Orange County, and I've been in jail since then.
So you put yourself into rehab?
I'm sorry, Your Honor. She has $250 restitution in 2129.
You able to pay that?
I would think her family can be able to pay that, Your Honor. I'll represent to the court.
When?
They hear anybody? Would you be able to pay $250 restitution?
Excuse me, Your
There's
Honor.
also other restitution.
There's another restitution. The cost number 2001. The amount of $3,200.43. So she has 3 cases.
I understand. Two, yeah, the first 2 were when she was placed on probation on February 5th, and the third one when she was placed on probation on October 28th
Yes.
of 2024.
The total restitution is 3,000.
Who's the 3,000? Who is that?
It's not written in that order. So I don't know. I don't have the old case with me.
To reset it for sentencing. See what,
No, let's see what she has in accrued time right now, and I've got a
well, I
plan.
know the court's adamant about restitution.
I know. And they're gonna, her family can pay that first restitution. What I want to do is dispose of these 2
I see.
and then keep her on.
I understand. I see where you're going.
Looks like our warrants were cleared pretty quickly, so she was in other places, but our warrants weren't.
She's got 165. So you see, you hear what, you see what I'm going to do.
Yes, I understand.
All right. But the restitution has to be paid or I'm going to undo it by the end of the day.
Up to 250 or?
Yeah, that's 250.
250.
Yeah.
Hang-
Yeah, he's going to tell you how to do it. Yes, ma'am. And we'll help you navigate through this so it can get done. Because the court has a plan here to try to whittle down these problems. Okay. All right. Anything else to add?
No, no.
Okay. Let's take up 23 CR 2129 and 24 CR 37. The court finds in each of these 2 cases that you have pleaded true in this first amended motion to revoke unadjudicated probation in each case voluntarily, knowingly, intelligently to allegations 1 and 2 of the motions, failing to report and failing to provide verification of performing community service hours. And you have admitted that voluntarily, knowingly, intelligently, and understanding and appreciating the consequences of pleading truth to those. That is enough to grant these first amended motions to revoke unadjudicated probation by a preponderance of the evidence or greater. And the court grants these first amended motions to revoke unadjudicated probation, and your deferred or unadjudicated probation is hereby revoked by this action. In these cases, on February 5th, 2024, in each of these two cases, you pleaded guilty to theft of property, a state jail felony in 2129, and unauthorized use of a motor vehicle in 24 CR 37. You made those pleas of guilty voluntarily, knowingly, intelligently. There was sufficient evidence supporting the guilty pleas from State's Exhibit 1 admitting in each of those cases to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt in those two cases based upon these violations of probation. And you are hereby sentenced to confinement in the state jail for 180 days. That's the minimum you can get. You will be given credit for 165 so far. So you see, you've got like 2 more weeks that you have to finish out the sentence. And restitution in the amount of, was it 200? What was the amount?
$250.
$250 is ordered to be paid in the judgment, which needs to be paid on or before the end of the day so that she can be released when she finished, as soon as she can finish these 180 days. That is in the amount of $250 to the complainant in 23 CR 2129 as her name is written in this indictment. Please get with the family members so that they get the name correct when they submit it for restitution. They send it to the probation office?
Yes, sir.
Yeah, you go to the probation office, which is not far, a block or so from here.
I'll explain it to you.
And there's a form a form of payment that they take, and we'll do that. We'll accept that. That resolves those two cases. On this motion to revoke unadjudicated probation in 24 CR 2001, the defendant has pleaded true to allegations 3 and 4 of this motion to revoke probation voluntarily, knowingly, intelligently, and that is enough to grant this motion to revoke probation by preponderance of the evidence or greater. And these are allegations of failing to report to the probation as required and failing to provide verification of performing community service hours. Again, the court finds that is enough to grant this motion to revoke unadjudicated probation by a preponderance of the evidence or greater. Your deferred or unadjudicated probation is hereby revoked. Earlier in this case, you pleaded guilty voluntarily. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this state jail felony, and you are hereby sentenced to confinement in the state jail for a term of 1 year. That is suspended. You were placed on regular probation for 2 years. There will be terms and conditions of probation that you need to follow so you can get released off of that early. But we're doing this because you are going to be released here on this one. You got to just serve 15 more days on the other two to satisfy those two by law. Then you'll be released, but you'll be on probation on this. And the key thing is You got to report or else you're not on probation. You have to, pay the restitution back. Quicker you pay the restitution back, get you out there, get you to, get an income, be responsible, fixing your messes. We all make messes. We all make mistakes. We have to fix them responsibly. That's the test for character purposes. We're helping you do your best and the best you can be. Do you understand where we are on this?
Yes, sir.
Okay. So,
Yes, no, Daniel is. Yeah.
but that restitution is, owed in an amount of $2,500. Did I say 2,000 or 3,000?
It's three, Your Honor.
$3,500, but you got to get that done before the end of probation. And the quicker you get it done, the quicker, that's the key to this case. When you pay restitution back, I consider releasing you early.
Yes. Thank you.
Yes, ma'am. Okay, everybody understand where we are on this?
Yes, sir.
Okay, any questions, ma'am?
No,
All
sir.
right, good luck to you.
Thank you.
Good luck.
But on strict
I know, well, you had to take them in a
No, it's good.
installments then.
And
Yeah. It's a new nightmare. It's the fee for the medical credit should be.
Yeah, I have a plea on Chelsea Schiff.
Yes, sir.
Okay, let's do that. Yeah.
She's in custody.
Do Chelsea Schiff, please.
Judge, I've got it on two,
Sir.
I've got it on two defendants with murder charges that are going to be pleased.
Okay, thank you.
This is the first one. This is the first one. The second one's going to be Cadrain.
Okay.
Mr. Reynolds is working on that. Just keeping me in the loop about what's going on.
Javiante Fontenot, what are we gonna do on that?
I have a motion to withdraw that.
Okay, that's two cases. Darren Patterson,
That we'd ask that get a reset so I can try to get that settled. Just
How long?
Just a regular reset.
3 weeks gonna be good?
Next week's
4 weeks good? Can we do 4?
we can.
All right, Darren Patterson, cause number 24, CR 110A. Mr. Burbank is the defense attorney, is requesting recess for 4 weeks in an attempt to resolve that. And Daniel Wally.
That's the state's motion, Judge. It has something to do with
Okay.
the
State's radio.
Okay. And here is Chelsea Ship. Does she need to be sworn in? All right, 22-40128 is called the state of Texas versus Chelsea Ann Marie Ship.
No.
That's you with Mr. Macon, your attorney and the state's attorney. Okay. This is a very serious case. They're all serious here. Some are more serious. Does the defendant waive a formal reading of this indictment and arraignment here? Can we proceed in summary?
Yes, sir.
In summary, this indictment alleges that on or about March 26, 2022, in Jefferson County, Texas, you committed the first-degree felony of murder with the use of a deadly weapon, namely a firearm, by shooting the complainant, the victim. Do you understand what you're charged with here? This is a first-degree felony, which means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range here now?
Yes, sir.
And it- I don't understand. So.
Is it because of the writing?
Yeah. What's
It's 40 years, Judge.
Okay, I'm gonna redo that, Jim. I know, I wish we had this pen for everybody. This pen seems to work better on the pad
Yes,
than
sir.
others.
Thank you.
And
Thank you for clarifying.
Okay. An agreement has been reached where you would be pleading guilty, sentenced to 40 years in prison. Is that your understanding of the agreement, ma'am? If I follow this agreement, you have no right of appeal of your case. Do you understand? You don't have. Stand up. How do you plead to this indictment, charging you with this first degree felony, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty. I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it? Discuss it with Mr. Meckin, your attorney? Are the contents here true and correct? State's Exhibit 1 is tendered into evidence. And without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment has been read to you. You read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer here. All of this is true. It states, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, sir.
Is there anything else to add? I'm going to make findings now. If nothing further to add by anyone, I'm going to find that Ms. Shipp, you are pleading guilty to this first degree felony of murder voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. You were giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, and you are totally satisfied with the representation provided by your lawyer. All of this is true, it states. So help you God, out of State's Exhibit 1, and the court supports those representations with positive findings that are in the record that state those admissions. I hereby find you guilty beyond a reasonable doubt of this first degree felony. I am following the agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 40 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used in the commission of this offense. Anything else we need to add on it?
No,
Is there any,
no, Your Honor.
nothing else from
No, sir.
anyone else?
Not today.
All right. Do you understand what has happened today, man?
Yes, sir.
Okay. That is all. We are in recess on this case.
Thank you, Judge.
Give Mr. Peterson, take Mr. Patterson's file too. public defender. People do not believe that any conflict exists, make waiver for the avoidance of all doubt.
Thank you.
Good morning.
Ms. Perry.
Assistant Public Defender Lauren Kearney, the Public Defender's Office likewise does not believe this. If one does, we also believe.
All right, the court for its part also does not believe there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matter. Am I waiting?
That's who I was calling.
Good morning, Judge.
I'm not gonna talk to you
You're not gonna talk to me.
unless you have good.
I'm asking for a really quick thing, but.
Denied. Court calls the case People versus Benjamin Coleman.
Allie Zed on behalf of the people.
Good morning.
Good morning.
Sherilyn Foster Tucker on behalf of Benjamin Coleman.
Benjamin Coleman.
In your honor, today's date, time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
All right. Well, being unable to proceed, this case is dismissed. That's without prejudice. Thank you.
Thank you, Your Honor.
Thank you. And can you come here for a moment? I need to talk to you.
I know. Don't be surprised.
Okay. Court does call the case People versus Adika Skib.
Ashley Lonnie for the people.
Kyle Burrell on behalf of Annika Skib, who's approaching the podium and will be standing to my right. Ms. Skib, once you get up here, please introduce yourself to the court.
My name is Annika Skib.
And we're this morning for final settlement that said people are unable to proceed.
Fence moves to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Ms. Skib has a tether on. Will she be able to go by today, or does she have to wait till tomorrow to go get the tether off from community corrections?
Keep it.
What do you think?
As much as I'm attached to it, Your Honor.
Literally.
Or it attached to you, right? She should be able to go over and get it taken off once they know that the case is dismissed. So before you leave here, you can turn your friend back in. Right?
Thank you, Judge.
Here. Court does call the case of the People versus Stephen Watson.
Allie Zed on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Watson, who stands to my right. Please state your name for the record, sir.
Stephen Watson.
Today's date, time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice.
Thank you, Your Honor.
Thank you. Court calls the case People versus Deontay Arnold.
Allie Zed on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Arnold, who stands to my right. Please state your name for the record, sir.
Deontay Arnold. Thank you.
In Your Honor, today's the date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That's without prejudice. All right. Thank you.
Thank you, Your Honor.
Okay.
Oh, you're good.
Court calls the case People versus Nicole Caldwell.
Ashley Lonnie for the people. Not yet, no.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Caldwell, who stands to my right. Please state your name for the record, ma'am. Nicole Caldwell.
We are set for final settlement. This time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Spencer Chambers.
Allie Zed on behalf of the people, Your Honor.
Good afternoon, good morning, Assistant Public Defender Lauren Kearney.
You were doing that all day yesterday.
I know I was.
I don't know what, and then when it got to afternoon, you said good morning, and then you.
I know, I don't know where I am, what time it is.
Oh, that lends itself to confidence. Go ahead.
Well, Your Honor, my client's not here. I did speak with him this morning. He lives in Lansing and does not have a car or transportation. So he could not be here. He was here in person for his last pre-trial. For the record, I would request an adjournment of the final settlement conference as the people cannot proceed on this case.
Your Honor, I would ask for a bench warrant. This isn't his first issue here.
It is not, it is his third. And then having failed to appear, bench warrant will issue. Bond will be setting him at $25,000. I'll give a 10% privilege on that. That warrant will issue immediately. Court does call the case of the people versus Haley Force.
Ashley Lonnie for the people. Assistant Public Defender Natalie Pay on behalf of Ms. Force, Your Honor, who unfortunately I do not believe is present. Our office did successfully make contact with her earlier this week and advised her this court date. I reached out to her again yesterday. Unfortunately, it was unsuccessful speaking with her. I do not have an explanation for her failure to appear, but for the record, I would respectfully request an adjournment of this final settlement conference.
Bench warrant will issue for defendant's failure to appear. Bond is setting him at $25,000.
Bless you.
Thank you. I will give a 10% privilege on that. That warrant will issue immediately.
Thank you, Your Honor.
I apologize.
$25,000.
1,000%. Thank you.
Court does call the case of the people versus Daniel Sims.
Ashley Lonnie for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Sims, who stands to my right. Please state your name for the record, sir.
Daniel Sims.
And Your Honor, we have reached a resolution in this case in exchange for a plea to an added count 2 of retail fraud in the 3rd degree, a 93-day misdemeanor, $500 fine or treble amount, contrary to MCL 570-356E4. That being retail fraud in the 3rd degree, retail fraud in the 2nd degree, currently charged count 1 will be dismissed.
That is correct, Your Honor, and that is what Mr. Sims would like to accept today. I do have the paperwork with me, the assigned advice of rights form. I do have the police report if the court would entertain a no contest plea. But I do understand the tardiness of the police report.
Pardon?
I do understand I am turning in the police report tardily.
Yeah, is he going to plead guilty or no contest? You know,
He was asking to plead no contest, Your Honor.
pardon?
It don't matter either which way, I guess.
He does he is fine to plead guilty, Your Honor. He's ready to proceed either way.
Let's have him sworn.
You solemnly swear or affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Go ahead, lower your hand, state your name.
Daniel Sims.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of retail fraud in the 3rd. It is a misdemeanor punishable by up to 93 days jail, $500 fine plus court costs. The fine could be increased 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. Do you understand that?
Yes.
And understanding that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yep.
Yes?
Yes, I'm sorry.
You signed an advice of rights form, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Look at paragraph 5. You see a copy on the podium. Those are your rights, which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
I am now.
Okay.
I am now.
Fair enough. At the time of this offense, were you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Has anybody threatened you or coerced you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty?
Yes.
August 10th, 2024, at the location of the TJ Maxx store on Carpenter Road. Yes, at 3158 Carpenter Road, Pittsfield Township, Washtenaw County, State of Michigan. What did you do on that date that makes you think that you're guilty?
I walked out the store with a backpack.
Okay, so you went into the store, correct?
Yes,
And you took a backpack
yes,
and you walked out without paying for it?
yes,
The store was open to the public at the time?
yes.
You didn't have anybody's permission to take that property, did you?
No,
And this backpack that you took was backpack that was offered for sale by TJ Maxx?
yes.
Counsel, have I complied with the court rule? Would it be proper to accept this defendant's?
Your Honor, it was more than just a backpack. There were other items as well, but if the defendant will stipulate to the amount of restitution being $249.86, I don't have an issue with the factual basis.
I believe it would be proper to accept this court's plea, Your Honor.
Yeah.
Yes, and we
Yeah.
would stipulate to that amount.
Court will accept the defendant's plea to count two. Count one is dismissed. Defendant is referred to probation for a pre-sentence investigation and report and determination of restitution. Sentencing in this matter will be
June 25th at 9 a.m.
June 25th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court calls the case People versus DeQuan Hardwick.
Ally's on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Hardrick, who is approaching the podium. Please state your name for the record, sir.
Daquan Hardrick.
In your Honor, today's date and time set for final settlement conference. At this time, the people are unable to proceed.
Motion to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice.
Thank you, Your Honor.
Court calls the case of the People versus Cyan Taylor.
Ashley Lundy for the people.
Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Taylor. Ms. Taylor, please state your name for the record.
Cyan Taylor.
Your Honor, we are set this morning for final settlement conference and 10 people are unable to proceed.
Move to dismiss.
People being unable to proceed, this case is dismissed. That is without prejudice. You want to keep your tether or you?
No, sir.
No?
No,
You sure?
I'm positive.
It looks great though.
No, I don't feel good.
All right. You heard my instructions. Probably
Thank you.
go over there and get it taken off. Thank you.
Thank you.
Court does call the case People versus Elizabeth Wilson.
Ashley Lundy for the people.
Good morning, Your Honor. Attorney Michael Kelly, T77187, on behalf of Ms. Wilson, who's present stating the right. Your name?
Elizabeth Wilson.
All right, you're good. All right.
Your Honor, today is the date and time set for final settlement conference. People are able to proceed. I understand that the defendant is going to be accepting the original offer of pleading guilty as charged with a prosecutor's deferred sentence. I'm sorry, she'll be pleading no contest if the court will allow. The police report I sent over this morning, I do apologize for the lateness, but that is something that we could not avoid, I think, in this case. So that is our request today for the plea.
That's correct, Your Honor.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and self you got.
I do.
Go ahead and lower your hand, and state your name again.
Elizabeth Wilson.
She signed an advice original.
She did, Your Honor. At our arraignment?
Signed a new one.
I do not believe so, Your Honor.
I don't have, I do. That she signed on December 11th, 2024. Does she recall signing that?
Do you recall when you originally signed this document? If you're originally-
Did I? I don't know.
And we also discussed.
Well, I'll pass it. She needs her rights and then I'll call you back up.
Yep.
Sorry.
Court calls case People versus Jarrell Davis.
Ashley Lundy for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Davis, who stands to my right. Please state your name for the record, sir.
Jarrell Davis.
Thank you, Your Honor. There is a resolution in this matter to which my client will be pleading to added count 2 of allowing an ineligible person to drive, and in exchange, count 1 will be dismissed. I do have a signed advice of rights form here.
And it is my understanding that Mr. Davis will be getting his license back next week, which is part of the reason for this reduction.
Yes, that is correct. And he did show me that paperwork from the Secretary of State that he is eligible and all his other holds have been
And this
lifted.
is not gonna abstract to mess that up.
It will not. Allowing an ineligible person to drive is not. No ops on a person, I believe, does, Your Honor.
Kevin's one.
Raise your hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Go ahead and lower your hand, state your name.
Gerald Davis.
All right. Sir, it is this court's understanding that you are going to plead guilty to the charge of allowing an ineligible driver to operate a motor vehicle. That's a misdemeanor punishable by up to 90 days, $100 fine plus court costs. You understand?
Yes,
Understanding that, you still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
You understand by pleading guilty, you'll not have a trial of any kind.
Yes,
All right, you signed an advice of rights form today, is that correct?
yes.
Any question about those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights of that.
Yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No,
Anybody promise you anything to get you to plead guilty to this charge other than what's been stated here today?
no,
Anybody threaten you or coerce?
no.
You're doing this voluntarily
Yes,
of your own free will
yes,
and because you believe that you're guilty?
yes.
Yeah, okay. On the date of May 27th, 2022, at the location of US 23 Famous Road in Pittsfield Township, Washtenaw County, State of Michigan, did you have custody or control of a motor vehicle?
Yes,
Did you allow someone who was otherwise ineligible to operate that motor vehicle, maybe inclusive of yourself?
yes,
All right, counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Anything you want to tell me before I impose sentence?
no, I'm ready to get this taken care of.
And you get your license back?
Yeah, I was supposed, it would have been Sunday the 8th, but I gotta wait till the 9th because it's on the Sunday.
Because it's on a Sunday.
So I gotta wait till Monday morning.
So how'd you get here? No, don't answer. Don't even, I'm not, I don't want to know. All right. I'll suspend 90 days in jail, fines and costs of $250. When do you think you can get that paid?
Next week.
Next week? All right, just get it paid. 20th. Give me
Okay.
next week on that, all right? June 20th. All right. Good luck to you. Drive safe, eh?
Thank you, sir.
Court does call the case, People versus Jada Taylor.
Castellani for the people.
Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. Taylor. Ms. Taylor, please state your name.
Hi, Jada Taylor.
Hello.
Your Honor, today is the date set for final settlement conference. The witness from Walmart was here earlier, Mr. Wright, and the defendant has elected to plead guilty as charged with sentencing under HIDA.
That is correct, Your Honor. She will accept that offer, and she did sign an advice of rights form.
That's sentencing under HIDA.
Yes, Your Honor.
All right. And Ms. Taylor sworn.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Go ahead and lower your hand and say your name again.
Jada Taylor.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of embezzlement by an agent or trustee, 200 to 1,000.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes.
Understanding all of that, do you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Yes.
Well, and to that charge, how do you plead? Guilty?
Oh,
not
guilty. Sorry.
How do you plead?
Guilty.
All right. You understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct? Any question regarding any of those rights? Look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record?
No. Nope.
Anybody threaten you or coerce?
No.
You're doing this voluntarily
Yes.
of your own free will?
Yeah.
And because you believe that you are indeed guilty of this offense?
Yes.
June 9th, 2022, at the location of 7000 East Michigan Avenue, that being the Walmart. Were you an employee of Walmart?
Yes, I was.
All right. What'd you do that makes you think that you're guilty?
I was an employee of Walmart and I was ringing up gift cards.
You were
Ringing up gift cards.
okay. You were a cashier?
Yes.
All right.
I was a customer service representative.
Okay. And you were ringing up gift cards?
Yes.
Explain to me, what do you mean you're ringing up gift cards?
I were loading gift cards. Loading gift cards.
You were loading gift cards. And when you were loading these gift cards, was somebody giving you money to load onto those gift cards?
No.
All right. What was your intent to do with those gift cards then?
Purchase stuff for my child.
Okay. Now, you were going to keep those gift cards and then use them to purchase items from the store.
Yes.
All right. And at no time regarding those gift cards did you supply the money that was the sort of the backing for those gift cards, correct?
Mm.
You came into possession of those gift cards as well as had the ability to load those gift cards by virtue of the fact that you were employed at Walmart. Is that correct? And nobody from Walmart gave you permission,
No.
correct?
Yes, that's correct.
And the amount in total that you loaded onto these gift cards, was that in excess of $200?
Yes.
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
The people are satisfied.
Satisfied, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be July 9th, 2025, 9 a.m. Bond will be.
Thank you. Thank you.
What am I calling? Court calls the case of the people versus Elizabeth Wilson.
Echelon for the people.
Michael Kelly, P77187, on behalf of Ms. Wilson, who's present, standing to my right. State your name for the record, please.
Elizabeth Wilson.
Did I have her sworn already? Pardon? Okay, all right. All right, you have been sworn, and ma'am, it's this court's understanding that you are going to be pleading no contest to the charge of malicious destruction of personal property less than $200. That is a misdemeanor punishable by up to 93 days of jail, $500 fine plus court costs. The fine could be increased times the value of the property by $500. That would become the maximum fine. Understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
Two things about a no contest plea I have to make sure that you understand is absolutely desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, sir.
Basis for the no contest plea?
The police report, Your Honor. That would be. Oh, I'm sorry. Oh, the base. Oh, concern for prospective civil liability, Your Honor. Caught me sleeping there. I was ready for it. I was ready for it. I thought you wanted me to give this exact number. I was like, okay, okay. Proceed.
Well, thank you. My court. Appreciate you giving me permission. Ma'am?
Yes.
To that charge, how do you plead?
No contest.
You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plea?
no,
Anybody threaten you or coerce you?
no.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
All right. Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-16-502. Any objection to the court having reviewed that report?
No objection.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court?
Satisfied, Your Honor.
Court will accept the defendant's no contest plea to this charge. Defendant is referred to probation for a pre-sentence investigation and report and determination of any restitution, and prosecutors deferred. Sentencing in this matter will be July 9th, 2025, 9 a.m.
Your Honor, can I get an alternate date on that? I'm supposed to be in Rochester at 8:30 that morning.
July 23rd at 9 a.m.
That works.
July 23rd, 2025, 9 a.m.
Thank you, Your Honor.
Bless you. Time to continue.
Thank you.
That they are. Unless you're standing, it's a product of the Scram Systems non-compliance report. It would be fined 500, can be admitted. And that's all we have.
I could have a week after I received the requested documents that I'm entitled to their file. To look
Well,
at.
you're entitled to discovery under the law.
Right. And I just need time to go through it, and then, so if I could have a week after I receive the documents, Judge, I will be ready.
Okay. Here's what the court's going to do, though. This is enough evidence to me. This is sufficient information for me to modify terms and conditions of bond. You're not going to operate a motor vehicle.
He does not have a car. He is not operating. Family member is, had brought him back and forth. You don't even have a license, do you?
No, sir. See, but all of that I understand, but the problem is if these are true, that indicate that he's using alcohol, he's testing positive for alcohol. Point is how do we prevent him on other than his word? I don't drive and I'm not going to drive. How do we prevent him from jumping in a vehicle? And the second time he commits intoxication manslaughter, it'll be shame on me.
Well, since he's made bond, Judge, I mean, besides that, he's complied.
This is everything.
He contests those.
And and he can say, I don't drive, but how do you prevent somebody? How do you know that they are? Unless you're standing with them all day long. You don't know. It's just your word and your promise. But here, this indicates that you are not good for your promise if it's admitted, if it can be admitted. And that's all we have is your word. I don't have any other physical abilities to keep you from driving unless I throw you in jail, which I'm considering doing if this test positive, because I can't control your actions if you don't follow the rules. I can't prevent you. No one can unless you are detained, because you can jump in a vehicle and we're going to do what we can to prevent that. The method that we've been using here, these scram devices, if these are admitted and properly, then that's going to be evidence that this court, which is enough evidence for this court to take some action. But I don't want anything bad happening in the meantime.
Well, Judge, he is still complying with the rules of the court in reference.
You mean like this having, like using the
Going back and forth.
like not using alcohol?
No, going back and forth to wherever he has to report to the scram, to give or change out the patch. And that is our position is that he has not ever been told that he's been tampering with anything, or that there were ever any problems with the people that he's communicating with.
Find out what the basis is, so you're.
But he has timely reported to change out. He's complied with everything. As I said, he has not, and yes, you can walk outside and jump in a car and whatever, but he has, to my recollection, I represent to the court that he hasn't, but there have been no problems, but we can test those. And the person that we subpoenaed, Judge, and I guess I'm gonna have to ask the clerk to maybe, so we can issue it, advised him that it wasn't his fault or there was a problem with it. It was environmental. And I think that's an issue. And I have it is in my subpoena that it should be in the court file. I formally requested a subpoena.
And you provided that information to the state?
Oh, good.
And who is that person?
It's in the subpoena.
Who, I mean, what's
Keep your subpoenas until they're actually served. They're not part of the court record.
No, but you had to fill out what we sent it down to you.
I don't keep a copy. You get the originals back.
Hold on, I got a file.
Same person. You have to bring this,
And I have. The only information I can see here is the state's exhibit 1. That's part of this record, but it's still. It's a product of the Scram Systems non-compliance report. Those series.
Can I show you, this is what I filed with the court, Judge? And it's a Mr. Simonette, Nick Simonette.
Okay, this was to be here on May 14th.
That was the last hearing.
Okay.
It was May 14th.
And
so we.
It's
to get in.
But it just says Recovery Healthcare Corporation.
Right, but in the bottom, I requested not only him, but for him to deliver his file with Mr. Rawls.
Well, but the court's orders are what they are. You can't operate a motor vehicle until further orders of the court. And you have to have an interlock device in any vehicle you attempt to operate. You understand?
Yes,
So you got kind of two parts that don't operate. And if you even tried, you have to have an interlock device. And if you didn't, that'd be a second ground that would be a mistake. That would result in if this court found out about that, your bond would be revoked if there's truth to that. And you would just sit this one out in jail until we can resolve.
Have you operated or tried to operate a motor vehicle?
No, sir.
But I don't, but once again, you're charged with irresponsibility in the operation of a motor vehicle by intoxication. This isn't going to happen on this. It's not going to happen a second time on this court's warrant. So you cannot operate any motor vehicle unless you have an interlock device. That's a condition of bond. Do you understand?
Yes, sir.
And you don't have to worry about it if you don't operate a motor vehicle.
I do not.
The other thing is that still the scram devices, we need to resolve that matter because this court trusts the scram device. As long as it's proven that there's no reason not to. My experience has been that they have been reliable. All right. What are we going to, what are we setting this for
You can
next?
just give, it can't be Monday, Judge, but if we could give them, so
How much
I
time?
just need his reports for a couple of days to.
As soon as the court can send it.
2 weeks.
That's
2
fine.
weeks, please. Thank you.
And if the state gets a copy of their report, through which I'm entitled to, through their, we guess it's gonna be claimed to be an expert.
Yeah.
We provided a copy.
All right. Sure. Let's get to the truth.
That's all I need.
What do you want?
Do you
Facts.
want to test them today?
Yeah, let's just do it just to be on the safe side.
I'll go take it out, go around over there. I'll wait.
All right, Ryan Kimbler, who do you have?
Mr. Randy, Your Honor.
So Randy, come on up.
See you while around the fence.
Yeah, come on up. 25 CR 144 is now called the state of Texas versus Shelby Nicole Randy. She is here with Mr. Kimbler. Her attorney and the state's attorney does the definitive formal reading of the indictment and arraignment here. We proceed in a summary.
She does, we made her.
In summary, this indictment alleges in paragraph 1 that on or about January 17th, 2025 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated. Paragraph 2 goes on to allege that you have 2 or more prior DWI convictions in 2014 out of County Court at Law number 3. You were convicted twice. And paragraphs 1 and 2 constitute the 3rd degree felony of operating a motor vehicle in a public place while intoxicated. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years. You would be fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. You must serve 10 days confinement in the county jail as a condition of probation. Do you understand what the plan is? And is this your agreement that you've reached with the state?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, which alleges those 2 prior DWIs in 2014, are those true and correct as they are alleged?
Yeah.
And are you pleading true and correct to this voluntarily and because it is true?
Yes, sir.
Show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered and passed.
No objection.
Without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've heard it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes.
State's Exhibit 1, made it part of the record without objection. And anything further, I'm going to follow this agreement. I will find then that you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here, which supports your guilty plea, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is suspended. You are placed on regular probation for 10 years. You will be fined $500. There will be terms and conditions of probation, normal and customary for DWI type cases. You must serve 10 days confinement in the county jail. When can you begin that? Immediately?
Yes, sir.
And probation officer will prepare the probation order.
Let her know they may not.
There will be other conditions, including completing a DWI intervention class. That's good. You must have, as you probably heard from the previous case, an interlock device in any motor vehicle you operate.
Yes.
That you have to blow in, it has to, you have to pass the test or else the ignition will not start the vehicle.
Yes, sir. I have one right now.
Okay, we'll follow those terms and begin your probation successfully, okay?
Thanks, sir.
Judge, you need to see it.
I have Kedron Perkins.
This is my home. So that when you are water.
Let's see, I have two cases. I have Darren Patterson with Langston Adams. Is he going to be here?
I haven't seen Mr. Adams.
There. He's been all over.
Oh, no, that wasn't Langston.
I have Denise Madrina.
She's here, Judge. Let's get the review on EST Monday and all.
Okay, I will take her next after this.
You not have that?
I don't have.
Okay, I wasn't sure. I mean, right? To be sure what was happening today.
At the conclusion of these, please, there will be one allocution, Judge.
Oh, these were add-ons?
Yes, sir.
Okay.
These
I
are-
didn't
Mr.
recognize his name.
Mr. Perkins is on Monday's trial docket.
Not anymore then.
Correct, Judge.
We're going to call two cases, cause numbers 22-39766 and 22-39767. The state of Texas versus, is it Kedron or Kedron? How do you pronounce your first name? Kedron?
Yes, sir.
Perkins. And you are here with your attorney, Mr. Reynolds, and the state's attorney. Does the defendant waive formal readings of these indictments? Can we proceed in summary?
He does, and you may.
Pleading to both?
Yeah, that's correct, Judge. Same amount of time to run concurrent.
In summary, these two cases, and we'll take them up together because they are similarly alleging the first degree felonies of murder in each case. And these state in 39766 on or about January 30th, 2022. And in 22-39767 on or about January 1st, 2022, both alleging in Jefferson County, Texas, that you committed the first degree felonies of murder by shooting the complainants or the victims in each case with a deadly weapon, namely a firearm. There's a second allegation of a prior conviction of robbery. Are we using that?
No, there's no need, Judge.
Okay. Do you understand, sir, what you're charged with in each of these cases?
Yes, sir.
These are first degree felonies, which means you face a term of life in prison if convicted, or any term not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreements have been reached in your cases where you would be pleading guilty in each case, found guilty in each case, sentenced to 55 years imprisonment to run concurrently with each case. Is that your understanding of the agreement?
Yes, sir.
If I follow these agreements, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Stand by, please. I show you in each case what's marked as State's Exhibit 1. Did you sign those documents voluntarily, knowingly, intelligently?
Yes, sir.
Did you discuss them with your attorney, and are the contents of these documents, State's Exhibit 1, all true and correct?
Yes, sir.
State's Exhibit 1 tendered into evidence in each of these cases?
No objection.
Without objection, admitted. Among other things, these state that you are mentally competent to enter your guilty pleas. These are freely and voluntarily made. You know what you've been charged with. The indictments have been read to you, or you've read them. You are guilty of the crimes charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. We're totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Is all of that true and correct?
Yes, sir.
States Exhibit 1 in each case made a part of the record for all purposes. Pre-sentence reports are waived.
So waived.
Anything else to add by either party? I'm going to follow these agreements.
Sorry, Mr. Thomas.
The only
And
thing
find
is,
you, in each of these cases, you are pleading guilty, sir, voluntarily, knowingly, intelligently, to these allegations of the first degree felonies of murder in each case. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of these two first degree felonies of murder. I hereby find you guilty beyond a reasonable doubt of these first degree felonies of murders in each case. And I am following the agreements. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 55 years on each case to run concurrently. There will be an affirmative finding in the judgments that a deadly weapon, namely a firearm, was used in the commission of these offenses. Do you understand, sir, what has happened today?
yes, sir.
Anything else from the state? Is there anything?
We have an allocution from the victim's family on 39766, Judge.
All right. Go ahead.
Judge, he is in administrative segregation because he was contacting witnesses. And I think since that's no longer an issue, he's asking that the jail staff be allowed to determine where he stays instead of the court.
That's an accurate statement as to why he was moved into isolation. We had proven to the court that there were some threats against one of the witnesses that testified. Since we're not moving forward with a trial, I have no objections to the jail making administrative changes.
It is allowed, based upon no objection from the state. What do you have?
I have some family, Judge. I know where you want to situate.
Okay, the defendant can be seated right here in the witness chair. Thank you. All right, please, in each case, please identify yourself and how you are related to the victim in this case.
My name is Sabrina Matthews, Wagner Matthews. I'm Isaiah's oldest sister.
That's Isaiah Wagner.
Isaiah
right,
Wagner.
Who was the deceased, who was killed in this case.
Sister.
Okay, go on.
Sandra Matthews, the baby sister.
Okay. All right, you may go forward when you're ready. Thank you.
Isaiah Brandon Wagner, a gentle giant, was taken from us on January the 30th, 2022. Our parents' lives are not the same since that day. My mom is 84, 666 since that day. There's nothing we can do or say to her to make it any better. We wrap our arms around her and tell her, I literally love her every day. Mama, it's going to be okay. Deep down inside, she doesn't think so. And she doesn't feel it. My dad is 84. Your parents and family and friends can go and visit you anytime they get ready. What we have to go and visit is a grave site of Isaiah. As one of Isaiah's oldest sisters, like I stated, we're a very close-knit family. All 5 of us. It was 3 boys and 2 girls. Our nieces and nephews, we're all like this. We come together in times of trouble and talk to each other and pray with each other, comfort each other, encourage each other. That's all we can do. He leaves behind 2 precious little children that between me and my sister and other family members help raise those children. Our husbands, they're here today to support us. They have helped in ways they didn't even ask for. But the love that they have for Isaiah's kids, that's what they do. That's what we all do. Jerry, my brother that's here today, you will always be our big brother, even though I'm the oldest. He's going to always be my big brother. It took us a long time, but not too long, to find out after Isaiah had passed, the grave site where the grass was growing at. It didn't take us that long to figure out it was him that was going out there cleaning that up. You took our loved one. I truly wake up some days in disbelief. I can't believe it. I touch it's real. He's gone. He's never coming back. I have a picture of him on my fireplace mantle. I pass by that fireplace mantle and I say, Isaiah, you don't even know what hit you that day. You hunted him down like an animal. For what reason? Oh, they said it was a girl. Oh, they said you disrespected me. How so? A human being. What happened to just talking? What happened to let's get together? When I was growing up, it was just, let's squash this. What happened to that? Take a life of another human and in that way. Coward, that's a coward. How could you? So disrespectful. on so many levels. I feel mad, I feel angry. I'm sad for my parents, most of all. I can't even imagine. I have 3 girls. I can't even imagine them dying and getting killed, not dying just from a hospital stay or sickness. They had pneumonia and died. They had cancer and died. No. He was gunned down and shot and killed. Not one time. Kedron, not one time. You shot him 41 times on Grand Street. Get my numbers right here. You shot him 41 times on Grand Street. As if that wasn't enough, not 1 week later, 50 shots was fired, and then the gun was unloaded on him. You got 55 years for that. 55 years. He's gone. My parents are dead. They won't see it. If my mama makes it, probably with her help, and I'm not being funny. If she lasts another, I hope so, 10 years. The way her health is right now, God is my witness. I have no reason to lie. I'm sworn in here before oath. Who does that, I say? Who does something like that? But a person who just does not care for another human. Today, I found out how many times he was shot, 41 times. I said that. How are you able to look at yourself for what you did? You will never forget what you have done for the rest of your life. You have a long road ahead of you to think about what you've done. So I say all of this to say this. You are a soul that Jesus died for. I believe in there's a place after this life. I believe in God. God died for you, he died for me. Yeah, Isaiah made some mistakes. I'm not going to get up here and paint a picture of Isaiah, that Isaiah was all that in a bag of chips. I'm not going to do that. Isaiah made some mistakes. So have I. So have you. So I say this. You are a soul that Jesus died for. You need to repent. I am a soul and a child of God that Jesus loves, and I need to forgive you. So, Kedron Perkins, I forgive you for what you did to my brother. May your soul rest in peace.
That's in church. Hold on. Anything else? We are in recess. We are in recess on this case. Thank you. Thank you.
I can get it later.
I'm all right.
That's your last one.
It's clear.
Yes, sir.
Yeah. You're clear, sir? Did you get a reset?
You did.
Okay.
I think we did.
You're clear to go.
I was trying to give me a resetting. Send it to me.
Yeah, 619.
Okay, who else is on the docket? I have a Denise Madreen.
You want
Already here.
Okay. We take care of that. Who else? Anybody else? Is that it? Anyone else scheduled? Yes?
Yeah.
No, you. Got lines through everything. Do we have another probationer?
Just that Ms. Vedra.
Yeah, that's just a review on her remaining balances of her restitution.
Who?
Denise, with drain. People laughing at that.
Okay. What'd you say? We already did that.
Yeah, we did one.
Okay, Denise Vidrine, that's you. 10-10405 is called. You're Miss Vidrine, and do you have an attorney still or no? Okay, you have, there's this motion to revoke probation that's been pending since June, 3 years now, 2022, which was all about restitution. And there's a lot of money here. You were sentenced to 10 years in prison, probated for 10 years for theft. A motion to revoke probation was filed prior to the completion of your probation. That has been pending, and that tolls or keeps the probation open. And we do that in cases where people still have restitution owed. And in this case, as of May in 2022, you were owing $212,415 to the complainant in this matter position. And so that's what we do. From time to time, we come back and update the status on where you are to ensure that there's money being paid as ordered. The court's very sensitive to victims. I think every court ought to be sensitive to victims, but I want to make sure that they're placed as close to whole as they were before they were victimized. So where are we on our loss here now?
Since
What did it start with? How much? Well, I want to get a basis line here. On the probation order, it was $265,137. And then it had been, looks like 40 some odd thousand had been paid back over the 10 years.
like $75,860.
Is that right?
That's $75,860.
What's the balance now?
The balance right now is $197,640.06.
A little over $197,000. How much are you paying a month?
$50. And then he's trying to get it too, so he's got that all right.
So what's probation office say? Anything we need to change on this?
So still watching, and since our last review was she had taken out $3,312 since November. Our last review, since our last review.
Yeah, but she pays $550 a month. Okay. So that's
Well. It's all restitution to restitution.
Ends up being about
To do something.
$5,000 or $6,000
every year.
per year.
So.
Which means at this rate, you only have 33 years to go. Okay. Right now, in your financial status, is this the best you can pay?
Very best. Yes, sir.
Well, it's better than nothing. Anything, other things we need to tinker with on this probation? She's not reporting probably anymore, right?
And she's I see her every other month.
Every other month, it's kind of just to check in to make sure that the restitution is being paid. Well, that's what boils down to the most important thing. So you were ordered, as all people are in this situation, to pay what you can. And the goal is to satisfy the restitution as ordered as quick as possible. But I think we all agree in this, understand in this case, it's going to take a while.
Yes, sir.
But keep plugging away. You get closer to the end. Anything else to add by the state?
No, Your Honor.
Okay. All right, from probation? Okay. Let's see here, was it 6 months? We
Supposed to be back here last month, but case moved to that.
Okay, let's see her back in December, first part of December. Okay,
Yes.
thank you. Please get a reset. Anything else? No, we are recessed. Thank you.
In State of Ohio versus Cassandra Renee Kuhar, case number 25 TRC 90. In this case, Ms. Kuhar, on April 29th, 2025, pled guilty to charges of operating a vehicle under the influence, a second offense in 10 years, a violation of section 4511-19A1A, and to one count of driving under OVI suspension. Both of those are first-degree misdemeanors, and the balance of the charges in this case were dismissed. The court deferred sentencing to today, and so we are ready to proceed to sentencing. Ms. Kuhar is present. She's accompanied by her attorney, Sean Martin. Also present is Law Director John Lewis. Okay, Mr. Martin, before the court imposes the sentence, is there anything you or your client would like to say?
Yes, Your Honor, thank you. Good morning, or good afternoon, I'm sorry.
It's all right.
Your Honor, I guess, I think I could start off with the things I think are, I think we can be thankful for here. Nobody was hurt, nobody was injured. My client's vehicle was the only vehicle involved in this. No other property was damaged. I mean, those are good things, and it's never the best to say those are the good things, but still certainly they're the good things. Nobody got hurt, and that's, I think, the biggest thing. As far as the rest of it, Your Honor, Ms. Kuhar clearly is struggling with some issues right now, and I think you can see from the letter provided by Lark, she is engaging with them for programming. She is set up for the DIP program. She's attempting to now address some of these problems. That doesn't mean what's happened is acceptable, but at some point, Your Honor, it's still better late than never, and it's still better now than before somebody gets hurt or something irreversible happens. I know that still is not the way we want people to conduct themselves, but You know, she is here today. She understands that there is mandatory jail time attached. She understands that there's the potential for a lot of jail time to be attached. There is also still the pending OVI out in Western County Court. She goes back for a pretrial on the 24th this month at 8:30. It's my understanding from speaking to PD's office, they're waiting to see what happens here. I know you're probably all too familiar with one court waiting to see what the other court does, being on either end of it. But with that said, Your Honor, I do think that anything outside of the mandatory minimums is not the proper sanction. Obviously, she has to serve the mandatory minimums. We can't, there's no way around that. That's state law. There's no way for you to deviate from that. But we would ask that you impose the mandatory minimums there for her. Certainly, I know one of the options is for the combination of house arrest and detention, and then, Your Honor, we'd ask for that. It would limit the amount of time she's incarcerated. She still has a job. She's still gainfully employed, Your Honor. At this point, she does provide for her children. Certainly incarcerating her for a longer time. There's no guarantee she would be able to keep her job for the longer stretch of incarceration. And certainly that would just really, any kind of push everything back further. So we'd ask the court just keep it to the minimums. And certainly I know my client is very nervous being here today. She understands that she's done some very serious things, and she's just here before the court to own up for what she's done. Thank you.
Okay, thank you. Ms. Kuhar, is there anything you would like to say before I impose sentence? Where is she working, Mr. Martin?
Are you still What's up? Yeah, you're still Your Honor, she's at Vibrance. Sorry.
No, that's all right. So she doesn't have anything else to say? Okay.
No, Your Honor.
Okay. Mr. Lewis?
Thank you, Your Honor. As Mr. Martin indicated, this was a result of a one-vehicle crash out on Plymouth Gageville Road in Sheffield Township. She did strike a traffic sign. I have received no information or anything about replacement of the traffic sign, so I don't think that there's anybody asking for restitution on that. But she did crash. Troopers went out to investigate, administered the field sobriety test to her, and she was placed under arrest for OVI. She refused the breath test. I did, when this plea happened, I did agree to recommend the mandatory minimums on the OVI, 2nd and 10, with probation. And I don't know if this has been brought up. I don't think that Mr. Martin and I have discussed it, but once maybe all of these cases are resolved, maybe a real court candidate here, Your Honor. I don't know. I don't think Mr. Martin and I have discussed that, but she still has that case pending out in Western County.
Yeah.
Thank you.
Okay. Okay, so I ordered Ms. Kuhar as a condition of her bond to go to LARC for an assessment and successfully comply with any treatment. I've been provided a letter from LARC. They did not provide this to me, I don't believe. I think this was provided directly to counsel.
Your Honor, that was provided to my client. My client provided that to me.
Okay. Which means she didn't sign a release, which is a bit troubling, but nonetheless. The assessment was done on March 3rd. So that's been 3 months ago. And I don't have anything, nothing's been provided to me about, because I did order that she successfully comply with any recommended course of treatment. What's being recommended in this report was the substance abuse group at Lark should be ordered or required to complete that. In the letter from the assessor, she did say that I have attempted to reach Ms. Kuhar several times via text, calls, and email, and I'm still waiting to hear from her and proceed, at which time I will let you know. Okay, Ms. Kuhar, what have you been doing with Lark? Did you ever pick up the phone and call them? Do you not realize I ordered you to successfully comply with any and all treatment recommendations at Lark?
She told me to wait to see him at the court morning. Last I spoke to her.
Well, I ordered you to follow any recommended course of treatment. So this incident happened allegedly, well, you've been convicted on February 8th. Here we are, June 3rd, and you've not been, other than being assessed, you've not undergone any treatment.
She told me to wait and see what I was told to do.
Here's what I don't understand. Why should you wait to be told what to do? You got a problem. Why don't you voluntarily get help?
I just do what she does.
Too many times it's the court being the one requiring people to get treatment. It should be the other way around. People should be voluntarily getting treatment and then coming to the court and saying, "Judge, look what I've done. Before you sentence me, look what I've done in mitigation of sentence." Instead, you're waiting for me to tell you what to do. And I will. Do these merge for sentencing? We have an driving under OVI suspension and an OVI.
No, I don't believe they would, Your Honor. I don't know what Mr. Martin feels about that. I don't think they would.
I think they would, Your Honor, but we would ask that the court consider that as a merged offense.
I am going to find that they merge for sentencing purposes. And so I will sentence on the OVI. 180 days in jail, 160 will be suspended. This is a commitment to the Asheville County Jail. This was a township case, so she will have to serve 20 days in jail. She is placed on supervised probation with this court for a period of 3 years. She's to have no criminal or traffic offense for 3 years. I'm required to, I'm the first to impose sentence, so whatever happens in Western happens in Western, but since I'm the first to impose sentence, she's going to be on probation with this court. She's not given any jail credit. I will allow her to serve 3 days of that 20-day jail sentence by attending and completing a driver intervention program in lieu of those 3 days. I will impose the minimum fine of $525. I'm suspending her license for 2 years. As a result of the refusal, I do believe she was placed under an ALS, but let me just double check. Yes, she was. Yes, she was. So this will become effective February 8th of 2025, so we will make this retroactive to February 8th, 2025. I will terminate the ALS to save her on a reinstatement fee. I will grant limited driving privileges. The hard time of 45 days has passed, so I will grant limited driving privileges upon the formal request for driving privileges, proof of financial responsibility, and other supporting documentation. Did you have insurance on the date of the offense?
Yes, I keep insurance because I still owe my car.
I don't believe that, I believe we've been provided a proof of insurance. Because the officer indicates on the ticket that we did not provide proof of insurance. So I will order her to provide proof of insurance on the date of the offense, that being February 8th, 2025, on the vehicle she was driving, to avoid any further non-compliance suspension. She's to do that by the end of the day today. I'm ordering her to submit to a comprehensive diagnostic assessment at Lake Area Recovery Center. I'm not sure, this being 3 months old, whether Lark believes another assessment ought to be done. But I'm ordering that she submit to a comprehensive diagnostic assessment at Lark for alcohol, substance abuse, and mental health purposes. She's to do that within 15 days and comply with any recommended course of treatment and then execute any necessary releases for probation to monitor. She's not to purchase, possess, or consume any alcoholic beverage or drug of abuse or any pseudoephedrine product, or go into any bar or liquor establishment for a period of 3 years. This sentence is consecutive to all other sentences, but will merge with subcase C, that being the OVI, or driving under OVI suspension charge. She is subject to a mandatory 1-year license. So I'm going to, I understand they merged for sentencing purposes, but there are other things that I need to do on the OVI suspension that are separate. I am going to impose a $250 fine, which is the minimum fine. The license suspension is a 1-year license suspension. That's mandatory. That's 1 year. I will commence that also on February 8th, and that will run concurrent. It's not going to be an addition. They're not going to be an addition to the 2-year license suspension I issued on the OVI. It will just run concurrent with the same license suspension. The vehicle has been immobilized, right?
It was, Your Honor, yes.
Okay, has that been released since?
Yes.
Okay. I did do an order, and that was clubbed, I believe. And so that vehicle, I believe that time was run, so I'm not going to order any kind of mobilization. So, again, this will, other than the fine and the license suspension, this will merge for sentencing purposes with subcase A. Advising Ms. Kuhar of her right to appeal, without cost, of her right to have counsel appointed on appeal without cost, of her right to have documents provided or necessary to file an appeal without cost, and of her right to have a notice of appeal timely filed on her behalf. Your total fines and costs are approaching $1,000. They may even be more than that, Ms. Kuhar. How much time do you need to pay all of that in full?
Your Honor, if we could have 90 days for that.
Okay. We'll give her until Friday, September 5th. To pay all fines and costs in full. Have I advised her of appellate rights?
You did.
I did, okay.
Yes, you did.
I thought I do it so often, I'm forgetting what I've said. Okay, Mr. Lewis, is there anything further?
No, Your Honor, thank you.
Mr. Martin?
Yes, Your Honor. As far as the matter of the 20 days, I know you mentioned for the 3 days.
Yeah, we'll give her a jail report date.
And if we could allow her to, she did clarify and check with her employer. If she does serve time on the weekend, she would be able to keep her employment, but the court allow her to do non-consecutive terms of incarceration to maintain her employment.
Well, she must serve 10 consecutive days.
Yes.
So the 10 days have to be consecutive. So I will make a note that 10 days must be consecutive. Now, so that we're not having to entertain multiple motions after the sentencing hearing, what is her normal work schedule?
Monday through Friday.
What shift?
First.
So I'll indicate that 10-day balance to be served on weekends. And that would be five weekends. Where you go in Friday night and you leave Sunday night, so 2 days. But the 10 days must be, the law requires consecutive sentence the first 10 days. So. Anything else, Mr. Martin?
No, Your Honor, thank you.
Okay, Ms. Kuhar, you're going to go to the clerk's window. They're going to take care of you, and then you're going to meet with the probation officer. For the next 3 years, you're going to be on probation with this court. If over the next 3 years you're found to have violated any of the terms of your probation, you do face an additional 160 days in jail. I could extend your probation from 3 years up to a maximum 5 years. And/or I could impose more restrictive community control sanctions, more restrictive than what I've already done. So I guess my point is, Ms. Kuhar, is you're going to be under the court's thumb for the next 3 years. So mind your P's and Q's and do everything you're supposed to do. And if you don't, you're going to be facing serious consequences. Do you understand all of that? Okay. This matter is concluded. Thank you all very much.
Thank you.
I thought I'd left with plenty of time to get through this flood detour on the turnpike, and well, it was kind of a mess this morning.
You be careful and safe and take whatever time you need to avoid that flooding.
All right, thank you, Judge.
You're welcome. Mr. Colby Sullivan. Mr. Dean, I think your camera may still be on.
I'm here, Your Honor.
All right.
Trying to find a place to stop here.
Is that Mr. Dean or Mr. Sullivan?
Mr. Sullivan.
Well, yeah, you shouldn't even have your camera on yet. Mr. Dean, thank you. Okay, I just wanted to let you know. Yeah, let's get you safe there. I don't allow people in court driving. Missy, what time is he on the docket? 10 o'clock?
Yes.
Okay. Well, if he'll pull his car over, I can talk to him.
Yes. 10 seconds, ma'am.
Okay.
Okay, I'm here. Sorry.
All right, we are not on the record, but I understand that there's been an attempt by you to turn in, is it a court-appointed attorney application?
Yes, ma'am. Last time we was here and I asked for a continuance, you told me to fill it out and make sure that I specifically put right on top of it, fill it out and put it in there because I was $250 over what they have on the internet site. When I got the paperwork, I filled it all out and I emailed it back. I have emailed it in 4 times. I've called the next day to try and verify that it was in there, and I got told, "We'll take your name and number and she'll call you as soon as she gets it." I never got a phone call back. I sent it again the next day. The final time I sent it was on the 25th of last month at 2:03 p.m. I called the next day and I got the same message. "We'll take your name and number. She'll call you when you get it." I never received a phone call. I called yesterday after I got the email about 9 o'clock docket today. And I finally got to talk to the lady, and she goes, "I have not received any emails from you or any paperwork from you whatsoever, and I don't have to call you." I said, "Ma'am,
Well,
I'm just trying to verify that you did get the paperwork so that way I know what my next steps are before court tomorrow." She goes, "Go to talk to the judge. That's not my problem."
well, it's the bottom line is you must, if you've made those many attempts, you must have the wrong email number. Because with 4 attempts, something's wrong in the picture. I don't know what it is. Did you confirm the email address?
It's the same email she emailed me from to send me the documents, ma'am.
Well, I don't know why you're not going through.
Because I tried twice from my personal email, and then I tried twice from the hotel email from the hotel I was working at.
Well, if we're not getting it, we're not getting it. And you know, if we don't get it, we can't approve it. But let's see if we can try to remedy the problem. So we still don't have an application. And I do see on May 9th, I advised you to fill out a form and send it in as soon as possible. And we continued the case to today, so you could do that.
Yes, ma'am. And I filled it all out, and I tried, like I said, I tried to send it back in.
Did you send that to my assistant, Missy, or did you send that to the clerk of the district court?
It was Missy. It was her. Missy was in. I put attention Missy on the subject line.
Well, she is not getting it. I still need a written application. Where are you located right now?
I am currently right now. I'm in just west of Andover right now, headed back to El Dorado. Does the courthouse in El Dorado have the forms for you guys? I can just stop by the courthouse.
Yes, they do. They do. We're all part of the same district, and I do traffic over there as well.
Because I can stop in the courthouse and fill it out real quick.
You're in Andover. Are you on the Turnpike or which highway?
No, I'm on Kellogg right now.
But you're not going to turn onto the Turnpike?
No, ma'am.
I'm trying to anticipate your time.
I'm not trying to get
I think that would be fine since you're not set until 10, and then ask them at the clerk's office if they could email that over to Missy.
Okay.
Will that work, Missy?
Yeah, that's fine.
Because if I understood you right, Mr. Sullivan, did you say I had denied you based on an oral exchange of information?
No, you didn't deny me. You said you wanted to look at my financials and you'd make an assumption from there. Because when I pulled up what the qualifications were for court-appointed attorney on the internet, it said I made $250 too much.
Well,
and when I got the printout, when I printed off the paperwork that Missy sent me, I was well within the qualification of it. It was 2 different numbers.
Well, and I don't know. Yeah, I don't know that the magic formula is on the internet, but yeah, let's just do it like you said. Just go to the courthouse over there and get the form and have them email it to Missy. She'll get it to me promptly, as she always does. And then we'll figure out. And if we have to give you a little, let's just do that. 45 minutes should be plenty of time. If it's
Yes, ma'am.
not, we can wait a little bit extra.
Okay,
All right.
I appreciate
Thank
it.
you, sir. You're welcome.
Yes, ma'am.
And let's take attendance for the 9 o'clock. So when we begin that, a little out of time today, we'll know who's here. Christian Drake is here. Lindsay Vopel? No, not here. And I see Abel Estrada. Missy, could you put his full name on there, please? Christina Glennon is not here. Stephen Jones, not here. Now, I do see Jessica Epting on my screen, but I'm not seeing her on my docket. What can you tell me about that, Missy?
She's on at 11 for a pay or appear.
Okay. Well, Miss Epting, we can probably take you up at the earlier docket. Since
Judge,
you are
I'm literally walking into my office right now.
Okay, thank you.
And in regards to Christina Glennon,
Yes.
I spoke with Ed Valatori,
Yes.
excuse me, this morning as I was driving in. I gave him a call, and because I saw his case back up, and I know we had resolved this case, but he said he'd yet to receive the diversion agreement from my office, which I was pretty sure I'd gotten on the phone during the last hearing. Contacted my office to get that to happen. I have no idea why that hasn't happened, but I have spoken with Jessica, and she's working on it right now and is going to email it over. Mr. Bettatori advised me, because I don't think he was planning on this hearing to happen, that he had a Jessica's Law sentencing at 9:30. I told him that I would ask the court to set this over to the next docket, given the fact that we had not received that or got him that paperwork yet today, but before today, and that he should go take care of his Jessica's Law case. So I'm assuming that's why Miss Glennon is not here. I told him we would have that emailed to him 2 days.
All right, well. We have continued that for the diversion for 1, 2, 3. This is the fourth hearing.
I have yet to figure out what the heck's happened on that, but I'm not relying on text message or emails anymore. I just called.
You probably just heard the one, the guy said he'd been trying to turn in his court-appointed attorney application.
I was listening to that. Sometimes technology is fantastic until it does something of that nature.
Yeah, sometimes it thinks it's smarter than we are, and sometimes it is, but sometimes not. So,
Judge, I'm going to log off and log back in through my iPad, which should be.
very well. Thank you.
Thank you.
So, Missy, we only have 2 of the defendants from 9 o'clock on here. One of them being the 11 o'clock.
It appears so.
Yeah. Finally, it wasn't bringing up any of my toolbars to get the heck out of here. And they just all went away. All right, here we go. Much better.
Christian Drake is here. He's first on the docket. If you want to. You want to take up Mr. Drake, Mr. Dean?
That sounds good, Your Honor.
All right. We'll be on the record in the 13th Judicial District, the District Court of Greenwood, County, Kansas. This comes on for status conference in case number 2025 TR 89, State of Kansas versus Christian Michael Drake. Assistant County Attorney Paul E. Dean appears for the state, and Mr. Christian Drake appears in person and pro se. On count 1, speeding 74 and 60, a traffic infraction. And count 2, one-way glass or excessive tint. And this is an unclassified misdemeanor. So, Mr. Drake, I think you had inquired about a court-appointed attorney, but the infraction does not entitle you to court-appointed, and the one-way glass is punishable by up to 30 days, which would not entitle you court-appointed attorney either. However, that is, as you've probably been told before, that curious statute that if you take proof that you've removed the sunscreen to the county attorney, they will dismiss it. Have you done that yet?
No, ma'am. Can you hear me?
I can hear you fine. Thank you.
Okay. So prior or previous one, I sold that vehicle and I took documentation in to the courthouse, providing that I sold it, and we were supposed to go from there and see if it could be dropped that way or.
Well, I'm not did you take the sunscreen off before you sold it?
No, ma'am.
See, I don't think that would qualify under the statutes. Because it clearly says it has to be removed. You can't just pass it on to somebody else to break the law with it. But are you representing yourself today then, apparently?
Yes, ma'am.
All right. Do you want a trial on these charges?
I don't know. I'll pay the speeding ticket. The only one that I'm unaware of is the tent ticket. I've never had one of those before.
Sir, I recommend that I would approve you for diversion as well, if you want to consider that. That's essentially, I'm assuming that was explained to you during your first appearance, but if not, it's essentially an agreement where you end up paying the costs and fines and a diversion fee. And as long as you don't have any new violations during a 6-month time period, then the case is dismissed and there's no conviction on your record.
He does have a substantial number of traffic cases dating way back. I don't know if that would affect your decision or not.
Well, that's not what my certified driving record shows, Your Honor.
Well, I'm looking at the Odyssey file. I'm showing he's got something.
This is the second time we've had a dispute between the state of Kansas, Odyssey versus certified driving record.
Well, as you know, Odyssey just pulls up whatever they've appeared in court in over the years, not necessarily but I see guilty pleas for traffic is back at 16, 17. There's some civil things. There's one in 18, guilty plea. They're pretty much speeding, and there was a seatbelt thrown in, but and there's a 20. Yeah, there's but if you're going by a different system, it's your diversion, it's your rules, and it's your record. So
well, we can put that. He can go for an application, and we can check as well, see what we come up with through NCIC. But generally, I go off the certified record, so I don't. But generally, I've never had issues with certified record missing things.
Right.
I mean, occasionally there's something that doesn't show up, mainly because it's old, like back in the 80s or 90s.
Yeah.
But it's still a lot of that is on those records. So that's
okay. Well,
curious, to say the least.
I'll leave it up to you, Mr. Drake. If you want to apply for diversion, it'd be a great opportunity to keep those off your record. You'll need to call the Greenwood County District Court. That's Mr. Dean's office at, are you ready to take down the number?
Oh, hold on.
Well, I think, Mr. Drake, I think you've been talking to my office. I think you talked to Jessica or Arlene, according to some notes they provided to me. So it's the county attorney's office number that you've spoken with when you provided the proof that you sold the vehicle. So that just call them if you have that number still.
I went in person just there in town in Eureka. Another question I have, I sold the vehicle, correct, but if there's a way I can prove that the window screen's been removed or see if I can pay to get it removed, is that a possibility where I can drop the charge without getting?
Absolutely.
Okay. Because I really don't want to waste a diversion on window tint.
Okay. Yeah, I think the issue on this, I'd be willing to work with you on that, and I'd be willing to give you a little time to get that accomplished. Your Honor, I think the issue was he was unaware of that, like so many people are, that statutory defense that if it's removed, it can be dismissed prior to selling the vehicle and then lost the ability to do so. But if you can work that out with the person who owns it, because it'd probably be to their benefit before they get that ticket.
Well,
it does seem to be a new emphasis by law enforcement. I hadn't seen those tickets for a long time, and all of a sudden there's been a slew of them. So it would definitely be to their benefit unless they want to get pulled over and cited.
Which I've never had a problem with the county by state troopers. So
yeah.
Well, and I think it's the state troopers locally I've been seeing enforce it. It's a safety issue for the officers. They don't want to walk up to a car that they can't see what the driver's doing. So it's an important rule. And
how long, sir, do you think it would take for you to make those arrangements?
Maybe a week. I've got their confirmation still, so I can get a hold of them and see what I can do.
Okay. Why don't we set this out about 30 days then, Your Honor?
Okay.
Or whatever Missy says works best for the docket.
And you might think about sharing with the buyer that it is a misdemeanor crime. It's not just a traffic infraction.
Yes, ma'am. I informed him that it would need removed, that I got a ticket on it, so I didn't lead him dark about it. I was unaware that it needed removed before in order to drop my ticket or however all that works. So
okay. All right. So you said about 30 days, Mr. Dean.
I think that'd be appropriate.
We'll have to go to July 18th at 9 o'clock.
July 18th at 9 a.m. Now, it could be, Mr. Drake, that you get proof to the county attorney, and then you may or may not want to pay that speeding ticket. And then but if you take care of both of them before the next court date, you wouldn't have to come back. But if there's any doubt, it's better to appear by Zoom than not appear.
okay.
All right. So I'm going to order that you reappear July 18th at 9 a.m. unless you've already taken care of this matter with the county attorney.
Okay. And on the tint, do I have to bring that vehicle in person to the Greenwood County Sheriff's Department, or how do I prove that it's been removed?
Mr. Dean, I'll let you answer that for me.
I think for the most part, there's a couple different things you could do. I would say a combination of things you could do as opposed to bringing it in for an inspection. If the vehicle is an Emporia, I suppose you could take it down to, they do a vehicle inspection. I don't know whether they inspect vehicles for that purpose, but you may be able to convince them to provide some kind of notice, because that is done by the Kansas Highway Patrol there at the Lyon County Jail. Okay. I'm not sure what day of the week they do it, but I'm pretty sure they do it weekly. There's usually a line of people, but I think also if you could get a photo of the vehicle with the bill showing that it's been paid to remove the window tint with it being removed, to me, that would be satisfactory.
Okay.
You do live here in Eureka?
Yes, ma'am. I could get a hold of Heath Samuels and see when the troopers are going to be in town next for inspection. And
Well, if you can get a hold of Heath, you can just have Heath look at it. As far as I'm concerned. Sorry, Your Honor, I didn't mean to cut
No,
you.
no, I was gonna say the same thing. Go ahead. That's fine.
I referenced him, poor Your Honor, I saw that his place of employment on his shirt there, and I believe that's Simmons, but.
Yeah.
Yeah. Yeah, either one of those, whichever is convenient to you, or if one works and the next one will. But, okay.
All right.
If there's nothing further, we'll be in recess until July 18th at 9.
Your Honor, I did want to advise Mr. Christian or Mr. Drake that, and that was July 18th at 9, that the speedy trial time, which is the time to bring you to trial, I'm going to mark on this journal entry that this continuance is at your request. Therefore, that speedy trial time isn't being counted against the state. It's basically stayed until our next court date. Do you have any objection to that?
Do you have any objection showing that continuance is at your request?
Yeah, that's fine.
That's
Okay.
what I would do.
That's all I needed, Your Honor. Thank you.
All right. Then Mr. Drake is excused.
Thank you.
You're welcome. We'll now call 2024 TR 577, State of Kansas versus Lindsay Veppel or Vopel. Paul E. Dean for the state. The defendant fails to appear. And this was licensed to be carried and exhibited upon demand. Second or subsequent conviction of, it says, well, that's curious because underneath of that, let me look at the actual charging.
Your Honor, did she bond out? Because this case is one where she was in custody in Reno County. We issued a bench warrant. I've got the journal entry of that because they said they didn't accommodate Zoom hearings.
Oh, well, it says she posted a $503 cash bond on April 29th of 25. So maybe she took the position that she thought that would let her off the hook.
Yeah, because that's basically what she owes.
It is.
Guess if the court can order that bond be forfeited and applied to the case, that's what I would request.
That is what I will do. I will order that the bond be forfeited. Well, I wonder if Topeka would take issue with that we should. I think I'll continue this to the next docket because I don't want any issue whether that should go to Topeka or whether she can pay her case with it. Missy, what's the next date for traffic court?
June 20th.
I continue this to June 20th and let me see where she lives. If I can. I can read her bond. Well, it looks like May 23rd, they sent it to collections. I'll order it to be removed from collections.
Yeah, I don't have the current bond, Your Honor. Well, hold on now. Maybe I guess I do. April was faxed over April 25th. I don't see an address on it.
She lives in Pratt over there. It's on the right instead of the left where I usually see it.
I was looking at the left.
Okay.
Looks like, unfortunately, we don't even have a phone number. I'll have my office as well try to reach out to her and let her know that if she can sign that bond over to pay the case, then I would be fine with her not appearing on that next date. Hopefully that would entice her to do so.
That would be fine, but rather than forfeit it, I'd rather she do that for her sake. All right, thank you. We'll be in recess on that matter. And then on 2024 TR 706 on the record in Christina Glennon, Paul E. Dean for the state. Neither defendant nor counsel, Mr. Battatori, appear, but I believe you had a statement about that, Mr. Dean.
Yes, Your Honor, that's a case that we've resolved via diversion. I know there's been a number of hiccups, and I have no idea why, because right there on the front of the file is the diversion agreement I've written out that was to be used. In any event, there's been miscommunication in my office. However, the diversion agreement is being prepared, and this morning will be emailed to him this morning. Mr. Battatori advised me that he had a Jessica's Law sentencing that was occurring at 9:30. I told him that I was running behind due to that mud route and the fact that we got more rain yet again last night, which was not helping anything at all. I slowed it down more than what I anticipated this morning. And then I would ask that the court continue the matter. He said he had no objection to that, appreciated it, and we would get it emailed to him today.
I think the July 18th date is.
Yes,
workable.
I have no doubt that Ed will get his client in to sign it and take care of it immediately.
Missy, will that work? Put that on the July 18th docket at 9, anticipating that we can remove it by then. Okay, thank you. We'll now be on the record in 24 TR 548, State of Kansas versus Stephen Jones, Assistant County Attorney Paul E. Dean for the state. Stephen Jones does not appear either in person or by counsel. This is a diversion revocation hearing, a motion to revoke diversion. Here's the diversion agreement. The motion to revoke was filed April 22nd of 2025 by County Attorney Jill Gillette. And notice of hearing by Zoom, certificate of mailing by County Attorney Jill Gillette says she mailed a copy of the motion to revoke to Stephen R. Jones at a P.O. box in Madison, which apparently is the address he gave on the diversion agreement. Checking that diversion agreement to confirm. There is a stipulation of facts, a waiver of service. The insurance charge was dismissed, but counts 1 and 2 were diverted. So, Mr. Dean, I'm not sure I'm finding his address in the diversion agreement, but you may have it somewhere else in the file.
Your Honor, the bond shows a 100 North 3rd Street physical location, but in Madison, there's only a couple of the streets that are considered on mail delivery routes, so everybody else has P.O. boxes. So, I mean, that makes sense to me that we would have gotten that from him. Let me see.
The ticket has the 3rd Street address. But you're saying that the post office only delivers to a couple of streets and
Yes, there's just, there's a particular route unless you're on, I believe it's Lincoln Street, McCurry. Unlike one other that I'm not, it's not 3rd Street. I know that. I know that.
all right. Well, I will find that pursuant to the agreement, he does have notice, but if he objects later on, we'll look at that a little closer and hunker
Yes.
there. So based on the defendant's failure to appear after notice, this will be considered a default judgment. Defendant revoked. And we can either set it for trial and you can try to give him notice again, or we can issue a warrant and set it for trial on stipulated facts when he's found. Which do you prefer, counsel?
Your Honor, I would ask that we set the new date, set it for trial, that we attempt to give him notice. I do have a little bit of question about the address. I do see where the P.O. box number appears on the diversion application, but he's not the one who wrote that on that application. It's clearly written in somebody else's hand and somebody else's, in a different color of pen.
Okay.
And he had written the physical street address. So let's do that just in case there is an issue with that. I don't want to issue a bench warrant because somebody in our office wrote down the incorrect P.O. box number.
All right. So do you want to put that on the July 18th docket at 11?
Yes, if we have time. Missy, thanks for the time.
Yeah, that's fine.
No, we'll set that for trial on stipulated facts, July 18th at 11. And then we have an 11 o'clock defendant on here that I told her we'd go ahead and take her up even though she's early. I think that's a payer appear, Jessica Epting.
Let me get that file, Judge. Okay.
We are on the record in case number 2024 TR 542, State of Kansas versus Jessica Jean Epting, County Attorney Paul E. Dean for the state, and Ms. Epting appears in person and pro se. She was to have the $453 balance paid by today or appear. And it looks like she still owes that according to court records and her appearance. So, Ms. Epting, where it doesn't look like you paid anything?
I'm having trouble finding it online. I went to the Kansas Public District Court portal and it tells me I can't pay it because it's an unpaid fine. So is there another website I can go to pay it? Because I would like to get it taken care of.
Well, at some point, they do make it where you can't pay them if you don't pay them in time or if they're turned over to collections. But what I see of your case, that shouldn't have happened.
Right.
I'm not sure. You could have always paid it the clerk of the district court. Now, did you pay a cash bond November 12th of 24? According to my file, you did. Oh, cash surety. I'm sorry.
Yeah.
As I say, if you paid in cash, you could have taken it out of your bond. Okay, here might be the problem. March 6, 2025, the state filed a motion to revoke non-reporting probation. And that, Ms. Gillette filed that. Motion to revoke non-reporting probation on the grounds that probationer failed to complete special conditions. The defendant failed to report for court-ordered sanctions. So this is not just a payer appear.
Yeah, that's when I don't know if you recall or not, but the paperwork got messed up. So I couldn't go. I went to report up there to the jail and they told me I couldn't report because they didn't have the paperwork. And the lady then told me that since I went to court they filed on a Wednesday, and she said there's no possible way they would have got the paperwork on Friday. It would have been the following Friday. But I had prior arrangements to go to rehab for 30 days, and then I got out, and then I did my sanction. So
Looks like there was another order filed, Judge, on April 22nd that she was to report on April 26th at 5 and serve 48 hours.
I did that.
All right, so we've got that taken care of, but then there's the pay or appear issue that you haven't paid anything on the 453, is that right?
Yeah, and I have it. I just don't, I have no vehicle to get there. So, I mean, can I mail it in or something? I don't know.
Why don't we give her a short extension and let her contact the clerk to get that paid, Mr. Dean?
Yeah, and the portal she was talking about, I don't think that was necessarily the correct location. It's at Kansas.
Sorry.
Judge, you know that email.
I used to, but they have made that so complicated. It has the words municipal court in it or something. I refer them to the clerk because it's just unbelievable what they've changed that to. Unless, Missy, you have it.
Well, it's PAYKS.
PAYKSCO.
COURTS.gov.
Okay, well, that's the old one now. Don't they have a new one?
No, if you go there,
It'll
will
give you the other site. It'll give you that long drawn out thing. Okay. Yeah, I don't even try to give it to you because it's just too complicated what they've done to it. But from what did you try to try paykscourts.gov?
No, I just went on the Kansas portal, and I'm pretty sure it actually took me to paykansascourts.gov. But I'll keep trying, and if I can't, is it the clerk of district court or municipal court?
District.
They may be able to help walk you through that as well. If you get on the website and have an issue, I would maybe get on that website, and if you're having an issue, call them then, and hopefully they can speak to you then, and perhaps they could walk you through that. They're going to be far more familiar with it than Judge or I.
Exactly. So their number is 620-583. 8153.
8153?
Yes.
Okay, I will contact them today.
And
do you have your case? I'm sorry.
Go ahead, Missy. No, go
Do you
ahead.
have your case number?
Yeah, I believe it's on the docket that you sent me through the Zoom.
Well, let's make sure it's GW for Greenwood. Dash 2024, the year of the incident, the crime, the traffic. And then there's a dash on the TR for traffic. And then dash 542.
Now, do I have to, when I go on the website, do I have to put the zeros?
I would suggest you just call the clerk first.
You have to put the zeros.
Okay, 3 zeros and then 542.
Okay.
Yeah, I used to be able to just tell you exactly what to do, but they just, for my brain anyway, it's gotten too involved. So maybe I'll work on that. But if you'll just call the clerk, they'll tell you all the options. They'll tell you if you want to pay in the mail, in person, and so forth. But let's give her a new court date. What's that one in 2 weeks? Do we have time then?
July 20 or June 20th at 11.
All right, let's set this for June 20th at 11.
Okay.
And that way, even if you want to mail in the payment, but make sure you don't send cash or maybe send it certified. Don't forget to put the check in the envelope.
Okay, would that be 9 a.m. or 11 a.m.?
11 a.m. 11 a.m.
All right, thank you.
You're welcome. All right, you're excused and you don't have to come back at 11 o'clock.
All right, thank you.
Today. Okay, now then, let's take up Abel Estrada Jr. Mr. Estrada, you'll need to start your audio and your video.
And
Okay, all right. We are on the record in 2024 TR 617, State of Kansas versus Abel Estrada Jr. Assistant County Attorney Paul E. Dean for the state. The defendant appears in person and pro se. The defendant, let's see, this first appearance back in October of 24. After being dismissed and refiled from municipal court and some failures to appear, then we had a bench trial February 14th, 2025, and the defendant was found guilty and ordered to pay $108 in court costs and the scheduled fine, with the court specifically ordering that if he appeals, an appeal bond set at the amount of cost and fines had to be paid before or at the time of the appeal. We had a peer review February 28th, 2025. Somehow he was attempting and made some efforts to file the appeal without a bond. He had gone through a couple of attorneys and then ended up representing himself.
Also determine whether he's actually properly docketed it. He's told us that he has. He's told us that he's talked to people in the clerk's office and then it's taken care of. But to date, there is not one piece of paperwork in my file that shows anything from the Court of Appeals, which we would have received electronic notification. Should have received notification of the docketing, should have received notification of any motion that he filed to waive for the Court of Appeals to waive the appeal bond. I believe you referenced something of that nature several times. I might be mistaken on that.
That's why I was walking through the history. That's what I'm finding too. When he was here May 9th, 2025, another payer peer review. Let's see. The defendant said he is outside the jurisdiction of this magistrate as he is strictly under the appeal court authority, that he had an appeal court case number. So I could not enforce the order for appeal bond or sentence, basically. So, have you paid? It does, Mr. Estrada, did you pay the fine ordered of $158? The court file says you haven't. Looks like you had 108 court costs and a $50 fine for illegally display of license plate or not display.
Your Honor, I take that back. I think my office has finally found something.
Okay.
It just has not, the paperwork has not hit the file. Looks like transcript's been completed. Oh, well, table of, okay, we did receive, apologize, notice, court docketing notice, appellate court docketing notice. So I think actually at this point in time with that, and that, I don't know why it took so long to get to us, but with that, we can remove this case from this docket and we will take care of it at the Court of Appeals.
Let me see if I find everything. Okay, suspension.
I will have my office, I'm going to ask them to file that of record in this at the trial court level. That way we have that in there. Judge, you don't see, you can't see that from your end?
Well, let me see. I'm seeing the transcripts.
And we did receive a letter. It's probably an emailed letter, but it is appellate court case number 128,986.
Okay.
So.
Okay, I did find it. Thank you. Yes,
Current
please.
jurisdiction at this point in time from the district.
Okay.
So.
All right. Well, we will just wait and see what the Court of Appeals thinks about your conviction, and I guess they're not going to enforce the order to pay the bond. So if the Court of Appeals decides that piece of paper was sufficient for requirements of tag violations, they'll let you go and it'll be over. But if they find that the conviction should be sustained, that that piece of cardboard that you bought from someone was not a legal tag, then they'll let us know and you'll still owe that money. Now, what I'm wondering, Mr. Dean, I think we might need to look at what appears to be some suspensions on his record for not payment, because if those suspensions for non-payment were filed by our county clerk or our district clerk after the appeal was docketed, those may need to be revisited. If they were done by the Department of Revenue in Topeka at any point in time, I can't overrule or override them. You have any thoughts on that?
Your Honor, I don't know who would have initiated that, because the case had been on continuance. I mean, I think the order's quite clear in this case. They would have received that notice of appeal. So I guess we just need to reach out to the clerk's office. Missy, if you could reach out to them on that, maybe we could find out an answer to that. I would agree there should be no suspensions as a base from this case, but the Court of Appeals has indicated on the letter that I just saw that they considered it properly, timely docketed. The appeal was timely filed, so there should be no suspensions as a result of this matter until we're back here or the Court of Appeals says that it's overturned.
But Mr. Estrada, you might be mindful and check your driver's license and see if the status is suspended, because it could cause you some grief if you're out there driving around with a suspended license, even though we may be able to clarify it eventually and correct if it needs correct it eventually, but it could cause some headache for both you and for this court and the prosecutor having to come back and visit that. So,
and Mr. Estrada, why I've asked the judge's administrative assistant to check with the clerk's office because she's right down the hall from them. I think it would probably also behoove you to contact the Kansas Department of Motor Vehicles and question them about that status. You may find it easier to send them a fax, because they're quite difficult to get to get a hold of anybody by phone. In any event, that's all I have, Your Honor.
Okay.
Well, I did get 3 different letters saying that I needed to pay, and I called them and I told them that I'm already in the appellate court, and there's no reason why I should be suspended. Is this gonna cause me any more problems? Is this something that I can call you back so you can confirm to whoever I'm talking to?
You don't need to convince me of anything on that issue. What I'm telling you is I'm agreeing with you, but the state of Kansas, for some reason, has a different opinion, and I think they're wrong. I'm just telling you, you ought to probably reach out and try to speak to them further yourself. Perhaps send them a copy of the appellate court docketing statement, things of that nature. Maybe that'll help clear it up for them.
DMV, okay.
All right, Your Honor. Can we take a short break before we get into our 10 o'clock? I don't have anything further.
All right. We're just gonna hold tight until the appeal is done. I'm not gonna set another case this time, Mr. Estrada. You're excused from today's hearings.
Judge, could we take a break before we get that 10 o'clock going? Thank you very much. We'll take a 15-minute break and then we'll get started again. On the record, on the 10 o'clock. Yes, that would be correct. We might be able, I think he has all of them on the 10 o'clock, but let's check. I'm pretty sure that's what I saw, but there may be.
Oh, there's a Curtis Dixon pro se. Is Mr. Dixon here?
And it's Colby Sullivan.
All right, let's try those two cases.
Yes, Your Honor.
Here? Colby Sullivan, do you want to take up? Let's see, we'll take up Curtis Dixon. On the record in 2025 TR 91, State of Kansas versus Curtis Dixon. This matter comes on for status hearing. The state appearing by Assistant County Attorney Paul E. Dean and the defendant appearing in person and pro se. Mr. Dixon, you do not have an attorney. Are you going to get one?
Yes, Your Honor. I was wondering if I could have another 30 to 45 days. I start a new job next week, and I was wondering if I could have that amount of time to acquire an attorney.
What efforts have you made to obtain an attorney so far?
So far, I haven't made any. I haven't had any funds at all to retain one.
Did you apply for an attorney?
Yes, I did.
You were ordered to fill out an application. Did you do that?
Yes, I filled out the application the day you told me to do it and turned it in.
All right. And let me see what we found on that. You were denied, is that right? Well, I am not seeing the application.
I checked on at the courthouse and they said they couldn't find it. Like,
No,
okay.
I'm not seeing it.
Judge, that's the one I talked to you about.
Oh, with the, you said he had a check and.
There was a check stub attached to it.
And then you told him to send in another one. Did you send in the second one?
No, I did not.
All right. Well, if you had, we could have been moving along. All right. So let's, have I asked you any questions about attorney, or did I just tell you to send in the application?
You told me to send in the application.
All right. Well, let me try to see what I can find out right now. Where do you work?
C&G drilling.
C&G drilling?
C&G, yes.
And what do you get paid per month doing that?
Right now, 1,500 to 2,000,
So,
maybe.
well, so average about 1,750 if it's between those two.
Probably.
And are you married or single?
Single.
Do you have any children, minor children you support?
No, I do not.
And do you pay any kind of rent or mortgage?
Yeah, I pay a rent here at this house,
How much per month?
800.
And then do you pay any kind of utilities in addition to that?
No, that's utilities included.
Do you have any kind of automobile payments?
Yes, I do.
How much per month?
About 200.
You have other expenses, other bills besides your living expenses?
No, ma'am.
But you do have to pay food, clothing, personal items, gasoline, things of that sort?
Yes, ma'am.
All right. I will appoint Attorney Richard Paw.
Okay.
He will be on here at 10, but he'll probably want you to call his office. Can I give you that number?
Yes.
It's 316 303-0100. Please call him as soon as possible. And Missy, when do you want to reset this?
Let's set this for July 18th at 10.
Okay, be back here by Zoom with Mr. Paul, July 18th at 10 a.m. And I believe you are on bond. We will continue. Let me double check that too. Interlock and insurance. Okay. Looks like you posted a $2,500 recognizance bond on April 29th, 25, and I will continue that with all the conditions existing plus the added that you call Richard Paw today in the afternoon and that you reappear with him by Zoom July 18th at 10 a.m. Any questions about that, Mr. Dixon?
No, Your Honor, I will do that today.
Okay, thank you. Anything further, Mr. Dean?
No, Your Honor.
All right, then thank you, Mr. Dixon. You are released from today's proceedings. And we will now be on the record in 25 TR 49, State of Kansas versus Colby Sullivan. County Attorney Paul E. Dean for the state, and Mr. Sullivan appears in person and pro se. Mr. Sullivan was having a similar problem as Mr. Dixon trying to get his application here. He said he sent it 4 times, but who knows where these were going for a while. He went to Butler County. Did you have some grief getting that Mr. Sullivan over there at Butler?
Just a little bit, but they went ahead and did it.
No.
My employment status has changed as of about 30 seconds ago.
Oh, no. What happened?
I was let go. They let go 30 people today.
Oh, my goodness. So is this application current?
Yes, I just updated it because I was in the process of filling it out when I got the phone call from my GM. But I do have a job interview this afternoon.
Okay, good. What was the company? TGC
Group.
Group.
It's a subsidiary of Marriott.
Okay. All right. But you think you'll get another one soon?
Yes, ma'am. I'll probably have one by the end of the day.
Okay. Well, what were you making per month? Oh,
Per month with TGC, I was making about $3,200 a month.
married or single?
Single.
Do you pay support any minor children?
I have my 2 kids living with me.
So you're a family of 3?
Yes, ma'am.
Now, these 2 kids living with you, are they your children or you're just supporting them for someone else?
No, they are my children.
Okay, very good. All right. And then you pay rent or a mortgage?
Rent is $1,250 a month.
Okay. And then do you pay utilities on top of that?
Yes, ma'am. They fluctuate between $300 and $450 a month.
Okay. Pay an automobile payment?
No, ma'am.
Okay.
I
Any
do
other?
not own a vehicle.
Okay. Any other payments that you have to make regularly? Insurance, anything of that sort?
No, I got my medical insurance that I pay for myself.
Okay,
And that's that's $150 a month.
Okay. Well, I am going to appoint Attorney Richard Paw He'll be on here shortly, but I think he'll probably want you to call his office so he can get the files and talk to you after he gets those. I can give you his number. Are you able to take that down?
Is it the 303-1010 or 00?
0100.
Yes, ma'am.
Okay. All right. And let's give you a new court day. Missy, when do you want him to come back?
July 18th at 10.
July 18th at 10 a.m. So make sure you try to get a hold of Mr. Paw's office today. Not this morning because he'll be over here. But I always say the day that I appoint, and then, or at least within the next couple of days, and then be ready to go on your case and reappear July 18th at 10 a.m.
Yes, ma'am. Thank you, ma'am.
You are welcome. And let me take a look at your bond. I will continue that April 29th bond that you posted for $2,500. Oh, that's Scott Dixon. I'm sorry. Let me switch screens. I will continue the $7,500 bond surety that you posted on February 1st, 2025. And I will remind you that you need to follow all the existing conditions. Do not possess or consume any alcohol or illegal drugs or be around any places where that's available or being used. Make sure that you don't drive unless you're licensed and legally able to do that, including if you're required to have an ignition interlock device. And then the added conditions are to contact Mr. Paw and reappear by Zoom July 18th at 10 a.m. Any questions, Mr. Sullivan?
No, ma'am.
Mr. Dean, anything further from the state?
No, Your Honor.
All right, then you may go, Mr. Sullivan.
Thank you, ma'am.
You're welcome. And I think the rest of these are Mr. Paw's. That's the 10 o'clock docket. Is there anyone here that is not represented by Mr. Paw? And I think he said something about he may be running late today, but he's getting a new associate that hopefully won't be running late as much in the future.
Yes, Your Honor. Fortunately, there's only 3 cases. It looks like maybe 4 cases, but one of them just looks like a balanced status. So we should be able to work through this fairly quickly. He did send me a text, and apparently that case is dragging along. So I think all we can do is probably go into recess at this point in time. And then if we get people showing up early for the 11 o'clock, I suggest we start taking those. And we'll
Okay. I'm going to do a little inventory of who is here. So you may leave the screen if you want, but I'm going to take a little bit of attendance here. Is Zach Ashlock here?
And I don't think we've had any contact. I don't think there's been any contact from him since the last court date, Your Honor.
No. Well, he was supposed to apply for diversion, but it apparently hasn't been granted. How about Julio Cesar Gallegos Oliveras? Is he here?
Yeah, Judge, he's the one in the jail.
Okay, thank you.
And I believe Miss Garcia is probably interpreting.
That is correct.
Okay, with an interpreter. Thomas Davis?
Present, Your Honor.
Thank you. And then we've taken care of Mr. Dixon. How about Albert Ryherd? He's supposed to have an attorney, Mr. Garcia. What's the status?
That's correct. That's not Mr. Paul's case. That was we'll check with Mr. Garcia. I don't see him on here. See, I'll check on that, Your Honor, while you're checking on the balance.
Okay. And do we have, okay, we've taken care of Colby Sullivan. David Warden? David Warden? Okay, then we go into 11 o'clock. Who's the gentleman at the Greenwood County Courthouse? What's your name, sir? You'd come up and tell me? You, what is your name? If you'll need to come up to the microphone so I can hear you, sir. You're gonna have to come up to the microphone. Can you see if he needs an interpreter, Miss Garcia?
Señor, ¿necesita usted intérprete? I don't know where the microphone is.
Oh, okay.
All right. I'm just here.
What is your name?
Juvenal Olivares.
Miss Garcia, what is he saying?
He said Reinaldo Olivares.
Juvenal.
Bernal.
Olivares.
I'm not understanding what he's telling
¿Y
me.
qué es lo que quiere decir?
Yo nomás estoy aquí por Julio.
I'm just here for Julio.
You're just watching?
¿Solo está observando?
Sí.
Yes.
Okay. All right, then I'll let you go back and have a seat, sir. Thank you.
Puede volver a regresar a tomar asiento. Gracias.
Judge, I'm gonna work on some journal entries off screen while we wait. Mr.
All right.
Paul indicated he was entering the last plea and sentencing, so hopefully it's not too much longer.
Very good. Missy, do you know if any of the 11 o'clocks have been,
Yes. Okay, because I got kicked out up here. I'll get on.
I'm sorry, I'm driving.
Yeah, no, that's quite all right. But I don't know. I think. Okay. And I think we're good. Court does call the case of Arbor Manor versus Patrick Brooks.
Thank you, Your Honor. Paul Hughes, P 31986, appearing on behalf of the plaintiff.
Good afternoon. Your name? Patrick Brooks. All right. And where are we on this case?
Your Honor, this is a case that the defendant has alleged repairs needed to be made. There was a leaking pipe that was repaired. The remaining repairs are completing the drywall where the broken pipe was repaired. Unfortunately, the defendant will not allow us access during working hours. We're trying to arrange to have the drywall done over a weekend, and we hope to have it done this weekend.
All of that correct, sir?
No, they actually fixed the pipe that they actually worked on. They fixed that when I wasn't there. So I never said that I didn't want my apartment worked on when I was not there. I haven't been living there for almost 4 months now because you weren't able to, anytime you flushed.
Allow them entry into the premises?
Yes.
All right. So Mr. Hughes, on the record, he's allowing entry into the premises. So if you arrange it over a weekend, you can arrange it over a weekend, but he's allowing entry.
Perfect. Thank you, Honor. The balance of the rent is $2,957 plus court cost of $165. Do we want to adjourn this for a control date for the complete?
Yes. Why don't? Yes. So my next date is which? 13th next week. Will everything get done before next week?
I believe so. Yes, Your Honor. Now, I'm looking at the 13th. Yes, they'll be done.
Okay. Then I'll adjourn it to June 13th, 2025 at 12 p.m. noon. Okay.
Thank you.
We should
Honor.
have all the repairs done and we'll have to figure out what's owed on us.
And
all right.
And
you did
confirm
not file a
the,
written answer. Go ahead. I'm sorry, Mr. Hugh.
Yeah, and I was going to make a note that you noticed it as well. There's no written answer that you had required.
Is there a reason you didn't file a written answer?
No, I heard you say something about that last week when we did.
I know you were supposed to file a written answer by June 5th. So you missed that deadline.
Oh, okay. I was on.
So, that may waive certain things that you have on the case, but we'll adjourn it out 1 week to get the repairs done in place. All right. Thank you. Thank you.
Thank you, Honor.
Thank you. Forrest Knoll versus Tequila Smith.
Paul Hughes, P31986, appearing on behalf of the plaintiff.
Hello, what's your name?
Tequila.
Yeah.
Yep.
Okay, thank you. All right, where are we on this case?
Thank you, Honor. My client, it has been brought to our attention about the condition of her premises. It's the type of repairs that are going to require us to relocate her. They have an available unit probably on the 15th of June. Perhaps we could adjourn this case to a date after the 15th for us to relocate.
Relocate her.
Miss Smith.
They let you know that, or?
Okay.
Pardon?
What'd you say?
Did they let you know that?
Yeah, once I started going to court and stuff, they did say they got a unit, but they told me my rent needed to be paid up in full before they could move me.
That's not true, Judge. We'll move her.
So that's what she told me before I came to court, but the court was already filed.
We still have to address the rent, which is $1,500.
Right, we have to address the rent.
So I filed for rental assistance and I got $300 today, and I'm just gonna work on getting it paid down as much as possible.
Okay, so why don't you do this? You have 300 today.
Yep.
Then we'll figure out what the balance is, but if your unit's in a condition where you gotta be moved.
Yeah, for sure.
They won't be able to do anything until the 15th. I don't have the 20th, so I'd have to adjourn it to the 27th.
That's fine, Your Honor.
Okay.
Yep, and I should have more money paid by then too.
All right, so June 27th, 2025 at
June 27th. Okay.
PM.
Okay, thank
What time,
you.
Judge? 12? 12?
Pardon?
I didn't hear you. 12 p.m.?
No, at 3 p.m. on that day.
Okay.
How much is your monthly rent?
147.
147?
Mm.
Okay. All right. So even if we click over into the next month at some point, it's not.
Yeah, next month they said it's going up.
Okay.
Yeah,
We'll
her
worry
current,
about that.
her current rent, Judge, is $230.
It's 2:30?
Yeah.
Okay.
My papers say one something on this paper though, so they be confusing me.
Yeah, it's 2:30.
Anything else, Tequila, you want to know?
That's what the papers say.
No, you want, just listen. I'm just trying to figure out so that get you moved, right? Then we'll figure out what the rent is.
Okay.
Just try to get everything settled. You got a problem with trying to that way? Okay, all right.
It's going
Now,
on.
if you want to yell at me, but
I ain't gonna let you.
look, I just wanted to know that in case we have to click over into the next thing. But what we'll do is we'll see you June 27th at 3 p.m.
Okay, thank
and
you.
then pay the 300, and then because you had this back balance, pay whatever you can as you're paying it before the 27th. So then we can see where we are. Okay.
Yep. Thank you.
You have a great week.
You too.
Thank you, Judge. Have a good weekend.
You do the same, Mr. Kevin Asentowski versus Thomas Warren.
Thank you, Your Honor. Andrew Poter, P85101, appearing on behalf of attorney Lori Bruce for Kevin Ostentowski.
All right. And you are?
Kevin Ostentowski.
All right. Mr. Warren did not check in. Mr. Warren did not check in?
Correct.
All right. Would you like to take it to fault, counsel?
So with this case, the tenant's already moved out. I don't know if we need to necessarily enforce an eviction on his record, if we could have this defaulted against all occupants so that we can just get his possessions out. And so he won't have an eviction.
Determination case.
Yeah.
Raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give the truth, whole truth, nothing but the truth, self again?
I do.
A notice to quit for possession of premises was served upon the Thomas Warren on April 8th, 2025.
Correct.
Yeah. You're gonna have a problem here. I don't know that your client has properly invoked the jurisdiction of the court. Now that I look at it, they only gave an 8-day notice to recover possession of property, and it's got to be at least 30.
That would do it. I guess we'll see you back here then.
Well, I don't know that you can, because I don't think that can be corrected.
Right.
The only thing that I can do, because that goes to court subject matter jurisdiction, the only thing that I can do is dismiss the case. You'll have to send another 30-day notice to the residents at least, because if he's moved out, he's moved out.
All right.
All right. So case is dismissed. Lack of subject matter jurisdiction.
Thank you, Your Honor.
Thank you. Courthouse case of Westbridge Mobile Home Park versus Cindy Alvarado Lopez.
Good afternoon, Your Honor. Brian Taylor for plaintiff.
Hello.
Hello.
What's your name?
Cindy Alvarado.
And where are we on this case?
Right now, I've got the rent at $1523.98. There's cost of $183, so the total balance is $1706.98.
$1706.98. All right. Did you pay your $600?
No,
You're supposed to pay that yesterday.
I know,
Why didn't you pay it?
because I can,
Pardon?
I came to find somebody to give me that money. I receive paycheck next week, so
Okay, so you don't have the money?
no.
Okay. So how are you gonna clear up this balance?
I told you I receive paycheck next week on Friday because I lose my job, so it's my last payment check.
Okay. And are you working?
Not right now.
Okay, so you don't have a way that you're gonna get this money?
For next week, yes.
Okay. There's $1,700+ owed. How much is your check gonna be?
Is that gonna cover that?
No.
So if you get your check, how much are you gonna have?
Maybe 100, 1,200, something like that.
About 1,200?
Mhm.
And what day do you get your check?
Friday, next Friday.
And then if you have 1,200 at that point, then how would you pay the other 500?
I'm gonna figure out next week.
Huh?
I'm gonna figure out next week.
You'll figure it out?
Yes, gonna
Okay,
work
that doesn't
cleaning
help.
houses.
Okay.
Yes.
You'll be trying to work on something else.
Yes.
All right. So here's what I'm gonna do. If you've got a check coming next week on the 13th, and if I were to issue a judgment today, you would have until the 16th to get all of this done. But I'm going to do it this way. I'm going to find no tribal issue after hearing on this case. I'm going to grant a judgment for possession to the plaintiff for 1706.98. But I'm going to extend the date that you would have to pay it. I'm going to give you one additional week. So I'm going to make the writ the 23rd, that Monday.
Okay.
Okay, so
Yes.
you got to get all of that paid by the 23rd.
Fine, comma, Milo.
Okay.
Okay,
Yes.
all right.
Thank you.
Thank you. And if you stop up at the counter, they'll give you a copy of this judgment.
Okay.
Okay?
Thank you.
All right, thank you. Court does call the case of Westridge Mobile Home Park versus Philip Traver.
Fronting of the plaintiff.
Your name, sir?
Philip Traver.
All right, and how much is owing on this?
I have 1526.93 of rent, 184.25 of cost, for a total of 1711.18 as of today.
All right. And sir, how were you intending on getting this paid? You said.
Does that include the 546 that was paid yesterday? I was short on what I told you I'd pay for this week, but I still paid 546 yesterday.
Okay, so you paid 546 yesterday.
Yes.
All right, so if I take you at your word that you did that.
The cashier's check handed to Jeff in the office.
Well, it's okay. Just stay with me. All right. 50. So how would you make up the balance on that? It's going to be around 1,200 or 1,165, somewhere around there. How are you intending on getting?
Right now, I'm just in a time frame situation.
You're in a what?
I'm in a time, working with my boss. We've now got it set up to where I'm going to be back to 42 hours a week, plus possibly more. And I do other things. My plan coming into today was figuring on taking the rest of what's owed from May, the June rent, but there's in the next few days, there's going to be another 75 plus 181 or something, and then take $626 for July. And no matter what it takes between now and July 1st, I will have everything, including July 1st, July's rent paid.
All right.
And if I could possibly get my online payment capabilities back, I could start putting money in there daily or weekly, but they take that away when you're behind.
Right. Okay.
And so it can be showing progress every day, every week.
Okay, so here's what I'm going to suggest that you do. Try to work something out with the landlord regarding payments and how you're going to do that.
They usually won't. They every time something comes up, they just say fair housing and you walk down the road. That's why we end up here.
Well, I don't know if that's why you end up here, but here's what I'm going to do. There isn't a tribal issue for me, so finding no tribal issue after hearing, I'm going to grant a judgment for that full amount of $1,711.18. noting that you paid the 546 that you've indicated, and if they have that, they have to credit it toward this amount. I will extend the time that you have to pay to the 23rd, like the last individual. So you'll have to figure out a way to get that paid or work something out.
Does that include, because, I've gone through a gauntlet of possible ways to help. I've talked with a Hawk and I got denied for SER, and got calls in with Friends Indeed, Ypsilanti Housing, but Hawk told me that if I apply for the SER, I get 14 extra days. And I sent that tracking number into the email.
Well, I can adjourn it out to next week, but if I adjourn it out to next week, I mean, if you want to come back next week, that's fine with me. But if you don't have it paid, you're going to get the same date. You're going to get the 23rd.
I mean, I'll do whatever I have to do, but at this point in time, my plan is just because trying to get help myself, because I am a single person. I don't have any. I see a phone numbers and I call the phone numbers, and every time, well, this group helps, these people help. And every time I call, it's 5 more phone numbers, and I make a few more. And all it ends up doing is keeps me away from being able to go out and work and try to pull the money myself. That's why.
What would you like me to do? I can adjourn this out, or I can give you the time that you would get now. What would you like to do?
I'm not even 100%. Whatever gives me the longest amount of time, because I'll be out there working to bring.
In a lot of ways, it's going to be 6 1/2 dozen of another. But I mean, I'll adjourn it out to next week if that's what you want me to do. If you think that's going to help you in some way.
I think we can go. You said, well, how many days? 23rd.
Yeah, 23rd.
Okay, just go with that, and
okay.
Hopefully, I'll have. Yeah, well, at some point, I don't care what it takes out of me. By July 1st, I will have everything paid through that, including.
Right, and just so that you know, so I put it on the 23rd. If you can get it down low enough, and they may not agree to do anything, but you'd probably be able, if you're saying you're going to get it paid by then, you'd likely have a little bit of time to get that done before anybody shows up to try to kick you out. Okay. That's what I'm kind of plotting out here for you. Okay. Thank you. Thank you, Mr. Ingram. Court calls the case Ridgewood Apartments versus Amy Wise.
Good afternoon, Your Honor. Mark Schlesinger, appearing on behalf of plaintiff.
Hello. Hello, what's your
Where are
name?
you going, David? Do you want to ask if you could hand it? Oh, hand it to.
What are you trying to give me, little one? Oh, bless your heart. Who are all these people? Is anybody on here me?
Yeah, the one with the heart over its head. He's nervous. He drew that for you last night. He was very excited.
Counsel, a young man has handed me a picture that he colored, so I'm trying to understand what I'm looking at so that you can see it.
Would you like to?
And I'm trying to figure out if something on there's me, like the one with
the love heart over top of its head.
With the heart. Oh, that's me.
Mm-hmm.
Oh,
standing next to a tree.
Yes.
I did not bring the court gifts.
That's. I told him I wasn't sure if it was allowed, but
Judge, I'm gonna object. I don't think he's licensed, Judge. So I'm gonna object.
Thank you, young man.
Thank you, Kip.
All right. So where are we on this case?
So, Judge, we were here last. Ms. Wisner had indicated she's going to apply for assistance. I don't know if she has or not, and where we're at with that.
Yes.
So what happened?
They had some clerical issues that they had to clear up to allow me to reset the SER because the application was automatically defaulting to reject my application.
Gotcha.
And it was because they appeared to, because I don't have a biological father involved. They were conceived by sperm donor. Sorry, everybody, it's too much information. But anyway, they had to remove that because it looked like I was rejecting child support. But there is no other.
There is no.
Legally, there's no one else involved. And so they had to get that cleared up, which took the last week. So I was finally able to reapply today.
Gotcha. Okay, and so we don't know the answer.
Don't know the answer yet. Yeah.
Okay. All right. So what I will do is I'm going to adjourn this out 1 week, council, because to give time for that to happen and to give the 14 days. So I'll adjourn this to June 13th, 2025 at 1 p.m.
Okay.
Okay.
Next week, 1 p.m.
Next week, 1
Same time,
p.m.
same place.
Yes.
Okay.
All right.
Thank you.
All right. You two take care of each other. Thank you.
Thanks, Judge. Have a great weekend.
You do the same, sir.
Thanks, Your Honor.
Scio Farms versus Caitlin Bell.
Good afternoon, Your Honor. Casey Matson, PH 7729 on behalf of plaintiff.
All right. Good afternoon. Your name?
I'm Caitlin Bell.
All right. And how much is owing on her?
Your Honor, we have a total balance due including court costs of $2,879.38.
Okay. Somebody coughed while you were talking. So what? Give me that again. The total amount.
The total balance including court costs is $2,879.38.
All right. And ma'am, how are you intending on getting this paid?
Patty and I are actually in the talks of selling the home. We have a walkthrough scheduled for Wednesday at 2 p.m.
So you're looking to sell the home?
Correct.
All right. So what do you guys want me to do on this case, given that? You want me to adjourn it out or how do we?
Your Honor, in light of the fact that the balance is still due and owing, if we could get a judgment today to avoid coming back on this matter next week.
Oh, that was hurtful. No, go ahead. Yeah, because you're not going to get this paid down. You're just going to sell the home and kind of move on your way.
What I was thinking was from the sale, if we do come to that agreement, they would take what is owed and plus extra for possibly July and August, just to avoid this happening again.
Got it. Okay. Well, here's what I'll do then. There really isn't a tribal issue. So finding no tribal issue after hearing, I'll grant them a judgment for possession for that total amount of $2,879.88. Okay. I will, however, you still have things in the unit.
Yes, we are still currently living there. I can't really move. My brother's disabled, so it's not really feasible for us to move at this time.
Okay, so let me ask you this. If the home gets sold, how are you going to get yourself out? I mean, what's the overall plan, I guess?
Well, I would like to stay. It's a gorgeous home. I don't have any issues with the park.
Right.
We're allowed to stay. That would be fantastic because we need to be near his specialists.
Oh, okay.
He's got a very long list of issues.
Your Honor,
yeah.
We would still be requesting that judgment with the writ to issue in 10 days because there is no tribal issue.
No, I understand that. I understand what your position is on it. I'm just trying to give enough time. If you had to get out, ma'am, when would you be able to do that?
It wouldn't be until August. If my hours at work have been cut severely, I lost 50 hours at work just in 2 weeks.
Okay.
I'm working 2 jobs and one of them is an as needed basis.
Have you tried to get any assistance to?
I am gonna be calling Hawk back this afternoon. We have been in contact with them.
Okay. So here's what I'm going to do. I'm going to grant that judgment, but did you do an SER?
I honestly don't know what
State
that
emergency
is.
relief
I
application? Likely didn't because you were headed along a different path. All right. Here's what I'm going to do so that there's ample time to do everything. Call Hawk back, explain your entire situation to them. I will, however, not have the writ issue until June 23rd,
Thank you, Your Honor.
2025. All right. Okay.
Okay.
Thank you. Court calls the case of Silo Farms versus LC Lou. Elise. What did I say? LC? I don't know why I said that.
Casey Matson on behalf of the plaintiff.
Your name,
Elise Lou.
which is exactly what it says. All right. Okay, where are we on this case?
Your Honor, there was a payment dropped off today for $918 via certified or via cashier's check. So the remaining balance is $2,142.64.
All right. How are we going to get that paid?
Well, fortunately, so I'm back at work because I was being treated for cancer and it's in remission. So I'm working again. My next check will be in 2 weeks from today. I had a check today. My next check will be 2 weeks from today and I can pay the full amount. 2 weeks.
2 weeks?
Yes, Your Honor.
So on the 20th, you can get everything paid?
Yes, Your Honor.
All right. Then let's do it this way so everybody doesn't have to come back. I'm going to grant a judgment for possession, finding no tribal issue after a hearing. Since she made that one payment. And that's for $2142.64. The writ won't issue until the 23rd. That next Monday after you get paid. Glad you're back to work. Glad you're doing well.
Thank you, Your Honor.
All right. You take care.
Thanks, you as well.
Your Honor,
Let's call the case. I'm sorry.
that was the 23rd, correct?
Yes. It
Okay.
was.
Thank you, Your Honor.
Thank you. Silo Farms versus Gregory Pennington.
Casey Matson on behalf of the plaintiff.
Mr. Pennington?
Yes, Your Honor.
All right. Okay, so what's the current balance?
Your Honor, I have the total balance right now is $2,589.30.
Okay, so that was $1,290. That would have been $2,000. Did you got that payment in that last time we were here?
Yes, Your Honor. The $800, and then I think it was a little over 1,000. I got paid for the day. I don't remember exactly. I didn't add it up. What was left over? But yes, I paid the first
you
one.
did say that you were going to pay the 1,000 today.
Yeah.
And then that was going to leave us basically June rent, but it looks like we're a little bit short, given the numbers.
Well, I didn't pay the 1,000 yet. I'm still at work, so after I get off work today, that's when I'm going to get the money order and then drop it off.
Right, I remember you saying that, sir.
Yeah.
So I guess I'm just, hold on a second. I'm trying to figure out. He was at 1801.73 last time we were here on May 30th. His monthly rent was about $1,300.
Yeah.
So I'm trying to figure out how this number gets to that point, because it should be a little bit lower.
They added on June. They added on June, probably. That's why. It's
no, Mr.
more.
Pennington, hold on a second. I'm asking the plaintiff.
Your Honor, there was, so the rent is $1,294. That was added for June. The water is $105.81. The sewer is $112.76.
There we go. Okay. Okay, that accounts for it. It's a water and sewer charge. Got it. Okay. Why my numbers don't look like they're adding up. Okay, and so you say you're gonna pay $1,000 a day, and then that would leave you about 1,500 or 1,600. And how are you intending on getting that paid?
Within 2 weeks, because I get paid weekly now, and within 2 weeks, 2 Fridays, not this Friday, but next Friday, I should have all of it paid up.
Okay, so you should have it all paid up by the 20th, you think?
Yes, Your Honor.
Okay, so here's what I'll do. I'll issue a judgment finding no tribal issue after a hearing. Judgment for possession for the 2589.30. That writ won't issue until the 23rd.
Thank
Then
you.
that will give you'll be able to pay it that Friday. I realize you get off of work late, so you need to get it in there by that Monday.
I was gonna say, if not, I do it on Saturday. First thing Saturday morning, if I get home late from work. Fridays, I usually Saturday morning. If I don't have time, I'll get it Saturday morning first thing.
Okay. All right. Very good. Okay. Thank you, sir.
Thank you, Your Honor.
Sile Farms versus Jarek Turgeon.
Casey Matson on behalf of the plaintiff.
Turgeon is not checked in. If you raise your right hand to be sworn. Did you get any communication from the VA on him? No?
My office did not, Your Honor. My client is also shaking her head.
Your Honor, we did not get anything.
It's a little strange because I think he was in the process of doing something. But anyway, if you'd want to take it default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do, Your Honor.
Go ahead.
Your Honor, we're requesting entry of a default possession only judgment. Rent to retain is $2,970.14. Court costs of $190.00 for a total of $3,160.14. For it to issue in 10 days.
Judgment to the plaintiff, that is by default for possession, redemption amount in the amount requested, writ issued in 10 days. Sile Farms versus Derek Wanchan, excuse me. And Elizabeth Wanchan. Hello, what's your name?
Elizabeth Watson.
Watson. What do I do with the H?
It's unusual, I know.
Is it silent?
It's silent, yeah.
Okay. All right. Okay, how much is owing on this?
Since June. Oh, I'm sorry.
Go ahead.
Your Honor, I have a total balance, including court costs of $2,905.46. She did make a payment of $800 on last week.
Okay. What's your plan for trying to get this clear?
As of this morning, Hawk did send me an email. They're still waiting on the ledger from the attorney's office and to go from there on what they can do.
Got it.
To help with that.
Do you know if a ledger's been sent over to Hawk?
I do not, Your Honor. I can check and see if we've received an email from them.
Okay.
I don't have
Don't have it. All right. Given that information, I am going to adjourn this out a week to June 13th, 2025. What time? 1 p.m. And if you could, who's your worker at Hawk? Do you know?
Autumn.
So we can make sure a ledger gets over there so they can see what they're going to do. In the interim, in the next week, can you get anything paid on it, or do you? Is it in between paychecks?
Next Friday, we can put down a minimum of 800, if not more.
On the 13th?
Yeah,
Okay. So I'll just indicate 800 by the 13th also. Okay? All right, great. We'll see you then. Court calls case Valley Ranch versus Kimberly. Is it Irizarry? Irizarry. I'm messing up everybody's name. It's okay. And also,
Saying Alcatraz.
yeah.
What is it? Everyone butchers it. Hussein Alcatrani, Your Honor.
Okay, Alcatraz. Okay. Thank you for jumping in.
Of course, Your Honor.
Otherwise, it was going to be a problem for me. All right. What is plaintiff's claim today on this case?
Your Honor, we have a total balance of $3,796.08. I note that they did make a payment of $1,050 on June 3rd. However, I haven't been able to verify that that payment's cleared yet.
Okay. Last time we were here, you said you're going to pay $1,400.
Yeah, I wasn't fully able to, Your Honor. I didn't work as many hours as I expected to.
Okay.
So, I didn't get paid that much. But
So you got the $1,050 you paid?
yeah, that I gave him my whole paycheck. So
Okay. So if I take that $1,050 off, we're still at about 28, somewhere around there.
yeah, and today possibly by the end of today, because I work at 3, I could pay another 1,000.
Today?
Yeah.
Okay. And then if that happens, it's going to bring us down. Well, that balance would be halved. And then how would you, well, it wouldn't be half. You take 2,000 off. You'd be about 1,800.
Yeah, which would be this month's rent, Your Honor.
That's your month. That's about your monthly rent.
yes.
Got it.
Yep.
Okay. So how are you guys going to get this all paid off?
So in the next, probably this week, I'll pay another, or next week, I'll pay another 1,000. And then
Right.
the week after that, I'll pay the rest.
On the 20th?
Yes, Your Honor.
Okay. So here's what I'm going to do. I'm going to issue a judgment for possession, finding no tribal issue after a hearing. I'm going to, since you made that good faith payment and I get you, your check is a little bit short. I'm going to issue the judgment for $3,796.08. That doesn't take into account the payment that you made.
Okay.
Okay. Next Friday, make that payment that you're going to make.
Of course,
And
Your
then
Honor.
next Friday, you can get this balance clear. And so no rent until the 23rd.
Thank you so much, Your Honor.
Okay. Let your paycheck get through.
I appreciate it.
Not a problem. And if I do it this way, I then don't have to try to butcher your name again.
Yeah.
All right. Okay.
Thank you so much, Your Honor.
Not a problem.
Appreciate
You guys take care. of
You as
yourself.
well. Thank you. God bless you.
Your Honor.
All right. Thank you, counsel. I think that's it for you, right?
Yes, it is. Thank you.
All right. Have a great weekend.
You as well.
Evergreen Apartments versus Denasia Hamilton.
Good afternoon, Your Honor. James Fink for the plaintiff.
Good afternoon. Hello.
Denasia Hamilton.
All right. And where are we on this case?
Her current balance is 2885.16.
2885.16.
And I'm just looking to see. Looks like she paid about $60 in the month of May. Don't make that about 180 in the month of May.
Is she?
I take that back. There was a payment made just yesterday, so
Was that about 400?
it was exactly 400, sir.
Okay. That's what she told me she was going to pay. So How are you gonna get the rest of this paid, do you think?
Well, I've been working overtime, so I'm trying. I did reach out to Cindy, I think her name is.
Who?
Sydney is one of the people in the office, and she gave me some more resources to look into. As far as I know, DHS is not helping. They keep telling me to call 211, and when I do, the only person is Salvation Army, and they tell me they don't help, but they keep referring me back to Hawk, and I told them I've been denied from Hawk.
Gotcha.
He's over the income level, Your Honor.
Okay. And you get paid every other week, right?
Mm-hmm.
When's your next paycheck?
On the 13th.
Okay. And so out of that one, how much are you going to be able to pay, you think?
I think I can pay about 500 because I'm not sure of how much it's going to be, but I know that the holiday that she said is going to be on it. But I am picking up a bunch of hours, so I really don't know how much it's going to be.
Got it. All right. Well, give me some time to work it out, but I don't really have anything to try. There's no tribal issue after hearing on this matter. You may want to continue to reach out for resources. I'll grant a judgment for the 288516, but a writ won't issue till the 23rd. Okay, so that at least gets you through that maybe two paychecks, but at least get you through one paycheck and get some additional funds and see what you can work out. Okay.
Okay.
All right. Thank you.
Thank you.
Evergreen Apartments versus Kayla Smith.
James Fink for the plaintiff.
Hello.
Hello,
What's your name?
Kayla Smith.
She's at
And where are we on this case?
299871.
Say it again. 49
299871. Sorry.
299871.
Just
All
under
right.
3,000. She has been approved and has some assistance coming that will cover almost everything. So if we could either set it aside or do a judgment.
When did they say that they're going to get that? We don't know.
They said within 2 weeks. The only thing because I paid the amount for June. So the only thing that should be over what they said they're going to pay is the late fee. But I talked to Sydney in the office and she said that she could waive the late fees if
they can get that paid.
Yeah, after they pay it.
So when did you talk to them when they said 2 weeks?
It was last Friday. They said Hawk said that they were going to pay, and then DHS said they were going to pay $520, and Hawk was going to pay the rest. And they said give them 2 weeks for the payment.
And that was last week.
Yeah, I believe so.
So this would be 1 week. Here's what I'm going to do on this one. I'm going to adjourn this out to the 13th. Let's see if we can get it paid prior to a judgment entering. 2025 at 12 noon. Okay, let's see if the checks get there.
Okay.
How about that? All right.
Okay, thank you.
All right, take care. Evergreen Apartments versus John Hudson.
James Fink for the plaintiff.
Hudson, no response. Raise your right hand, sir. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir, I do.
Go ahead, sir.
Yeah, this is an action for non-payment of rent. This defendant owes $1,128.93 in rent. The costs are $172 for a total of $1,393 possession only.
Judgment to the plaintiff. That is by default for possession. Redemption amount is in the amount requested. Writ issue in 10 days. Evergreen Apartments versus Nelsa Nieves Martinez.
James Fink for the plaintiff.
Oh, she is. Ms. Montanez?
I see her.
Here?
Yes. Hello.
Can you hear me?
Yes, we can hear you. If you can turn on the camera, that'd
I'm
be
trying to
great.
turn
Oh,
it
there
off.
she
There it
is.
goes.
Okay. All right. How much is owing on this?
Including costs is $5,488.17. She's eligible for Hawk, but she's got to pay the other 2,500 first, which was the 2,500 I think she said she was going to pay,
Yeah.
but didn't.
Did you get that paid?
No, I'm not going to be able to. My son broke his leg, and there's no way I'm going to be able to stay in his apartment and bring him up 3 flights of stairs. He's going to be out for at least a year with a bad leg.
Got it.
And he's
All right.
autistic.
And what was the total
Makes it
amount, Mr.
worse.
Fink?
$5,488.17.
Got it. All right. That's regrettable to hear, but I'm going to find, after hearing, find no tribal issue, I'll issue a judgment for possession in that amount with a writ to issue the 18th.
Thank you.
What does that mean, Your Honor?
What that means, I've issued a judgment. If this amount's not paid by the 18th, they can seek an order of eviction to have you removed from the premises.
Oh, okay.
Okay?
All righty.
All right. Thank you. Good luck to you.
You too. Bye-bye.
Glencoe Hills versus Devonta Jackson.
James Fink for the plaintiff.
And also La China Williams.
You got it right.
I got it. I got it. I didn't mess it up, Miss Williams. Did I?
No, you didn't.
Okay, I'm gonna have to be honest. I don't know what I would have said, but my judicial coordinator was in my ear saying La China. So I didn't mess it up. All right. I'd love to be able to take credit, but I can't. All right. Okay. What is plaintiff's claim in this case?
Including costs, $2,981.61.
All right, Ms. Williams, how are you guys going to get that paid?
Well, I heard from Hawk. Well, I had a caseworker named Caitlin. I only heard from her from the intake visit about seeing if I could get approved for the funds, but I haven't heard from her since then. And I've been emailing and calling, but I got nothing. And DHS denied my SCR twice.
Got it. So, Mr. Fink, you see anything regarding? We don't have Amy today, but
Just our notes just say that no one's heard anything since the last week of May. I think it was the 27th.
and ma'am, how often have you been trying to get through to them? They just can't.
I emailed Caitlin 4 times since the last week, and I called there 3 times. I called them today, and they said they would reach out to her, but I haven't heard anything.
They can't do this to people. Well, this number's not going to get any worse. I'm going to adjourn it out 1 week. Ma'am, you just keep trying.
Okay.
And let's see if we can get somebody to tell us yay or nay. And then we can figure out where to go, right?
Okay.
June 13th, 2025 at 12 noon.
That's over the plaintiff's objection, Your Honor.
Pardon?
It's over the plaintiff's objection.
Of course it is.
Thank you, sir.
I'm going to do it anyway. Let's just see. She's trying, but people have to give people answers.
I understand.
All right. Thank you, Ms. Williams. Huron Vista versus Wilbur Burrell.
James Fink.
Burrell, not here. If you'd like to take a default, you may proceed.
Your Honor, this is one of the, actually, all four of these defendants have agreed to participate in that payment plan that I know the court's aware of for here in Vista.
Yes.
Could I, how about if I take a default on the record and either submit a COD or a judgment under the 7-day rule?
Okay, that's fine. That's fine.
And if we enter a judgment and he participates, then we'll set it aside.
Okay, very good. So what are your proofs?
This defendant owes $1,347 in rent. The costs are $176 for a total of $1,523 possession only.
Judgment to the plaintiff, that's by default for possession, redemption amount, in the amount requested with the writ issue in 10 days. Huron Vista versus Alicia Moore.
James Fink for the plaintiff.
Oh, she's here.
James, I'm sorry, she's coming up.
Yes, she is. Hello.
Hi, Alicia Moore.
Okay, she's here. Were you participating in the program there or?
Yes, I do have a question. Maybe I need to talk to my leasing agent because the guidelines is saying that they'll give a 1 month forgiveness, and I didn't understand which month they were forgiving. Being that I'm paying June and Hawk is paying the back pay. I just wanted to know what they were, because it's very intense. Once you sign that paper, it's like very strict guidelines. So I want to make sure what they're actually waiving.
I can answer that, Your Honor.
Yes, sir.
They will waive up to 1 month's rent. So it would be the balance that's due after Hawk makes the payment and she makes her payment plan payment. She still has to pay June, July, and August on time, and she's probably going to have to be. She'll pay June. She'll have to pay July and August on time. Whatever Hawk pays will get credited, and then up to 1 month can be waived if she complies with everything through those payments. If Hawk pays the entire balance, she doesn't get a credit, but she can have the balance wiped out up to that amount.
Yeah, that's why I was a little confused because they're taking care of, I just have to do my part for this month. They're doing their part. What are we waiving?
Yeah.
Why am I doing this? I just don't want to set myself up for something.
No, I got you. I understand. I mean, there's not a lot of moving pieces, but you're just trying to make sure you do what you need to do.
Yeah.
Okay. Were you talking to the office about this?
I was, and there's a lead guy that's over in another area who handles everything. So I've been communicating with him. I don't want to,
Okay, let's do this. I don't want you to be confused about it. Let me adjourn it out 1 week, the 13th, 2025 at 12 noon. Give you an opportunity to talk with them more and clarify exactly what it is. How's that work?
Sounds great.
Your
Thank
Honor,
you.
could we would the court be willing to, with the information that has been provided, advise her of MCR 4.201J so that if she decides that she's comfortable and wants to sign the COD, she doesn't have to come back?
Okay, so that makes sense to you? If the paperwork gets signed, there are certain things I have to advise you on the record, or you have to be advised of before I can sign off on it.
Okay.
Right? So if you guys enter into an agreement, you sign off, you won't have to come back to court. And so I'm going to advise you of the rights under that right now.
Okay.
Okay? So, ma'am, you would have 3 business days from the date of my signing of the conditional order of dismissal, which it would be, to file a motion for the court to set that aside. All right? If for whatever reason there's some confusion, some misunderstanding as to what your legal rights are, or your belief that some right that you have you didn't assert. You'd have to file that motion within 3 business days of my signing. Doesn't mean that I would set it aside, but you'd have that opportunity to file that motion. You understand that, ma'am?
Yeah.
All right, very good. All right, so then maybe we can then get it entered. You don't have to come back.
Okay, sounds.
Okay?
Thank
All
you.
righty, you take care. Have a great weekend.
You too.
Huron Vista versus Jacqueline Taylor.
Good afternoon. Good afternoon.
Oh, she's here. Jacqueline Taylor and Tania
Tanaya
Tolliver.
Tolliver.
Tania Tolliver.
Yes.
And who are you?
I'm Jacqueline Taylor. I'm the mother.
Okay. All right. And Mr. Fink, how much is owing on this?
Including costs, it's 2363.03, and they are eligible for the payment plan.
Okay. So, Ms. Taylor, were you going to participate in that program at Huron Vista?
Yes, sir. We was communicating this morning, me and Mr. David. We're having some kind of difficulties with my portion of the rent. Section 8 gave me a paper saying they changed it in April. They gave them a paper saying they were going to change it in July. So he's going to look into it. He told me he would get back with me, but we're having some type of communication, a difficult communication with that part of the deal.
Gotcha.
Yeah, I think we're going to move her from June, July, August to July, August, September. So if we could do the same thing, Your Honor, set it for the 16th, or 13th, and hopefully she won't need to come back. We'll get it signed and done this week.
All right. So, ma'am, I'm going to adjourn this out to the 13th at 12 noon.
Okay.
Okay?
Okay.
If you work out all of the paperwork and sign off on it, then you won't need to come back to court so that I can then enter it. But from the date that I enter it, you would have 3 business days to think about it. If you believe that there's some confusion, some legal right you didn't assert, or some mistake, or otherwise there's some confusion on your part, you would have those 3 business days to motion to this court to set it aside. That doesn't mean that I would, but you'd have those 3 business days to think about it, okay?
Okay. Thank you.
All right, thank you. Huron Vista versus Rodney Taylor.
James Fink for the plaintiff.
Rodney Taylor did not check in. So I guess if you'd like to take a default on this, you may, and then set it aside, or I'll receive a COD in lieu of the judgment.
That's exactly what we're hoping will happen, Your Honor. Mr. Taylor owes $2,612 in rent. The costs are $176 for a total possession only judgment of $27.88 even.
All right. Judgment to the plaintiff, that is by default for possession, redemption amount, in the amount requested with the writ issue 10 days.
Thank you.
Thank you. Who's this? Peninsula Place versus Brianna Johnson.
James Fink for the plaintiff.
Hello.
Hello,
Your name?
Brianna Johnson.
All right. And applied through Hawk, what is owing currently?
Including costs, $3,489.98.
How are we going to get this paid?
So, the last time we talked, I had told you that I was having communication issues, and then I told you I could pay $750 yesterday.
Yes.
But I just didn't know, like, I never like did none of this before. So I'm trying to figure out like what's the process of paying it. So that's the only reason why I haven't paid it yet. But I didn't get as much hours, so I only got 400 instead of 750.
Okay.
But I also did Wednesday. Kaylin, she emailed Peninsula Place and she asked them for some documents. And she said once they get the documents to her that they could go through with the process. and then they emailed her back and said that they'll probably contact her at the end of this week or the beginning of next week.
Gotcha. Okay. So here's what I'll do. It sounds to me like there are people that may be able to help you. I'll find no tribal issue after a hearing on this matter. I'll enter the judgment in the amount requested by the plaintiff. However, a writ would not issue until the 20th.
I should be able to, so because I think that Hawk pays like at least 3,000, that should be already paid before then.
Right. If Hawk will pay it, you're going to be, and then you need the 500.
Yeah,
Which,
that should be paid way before then.
Right. So hopefully, that's why I set it out this way. Hopefully everything will get paid up. Just need Hawk to do their part. Okay?
Yeah.
All right. Thank you.
Appreciate it.
Yeah, that was Miss Johnson, correct?
Pardon?
That was Miss Johnson?
Yes, sir.